Sacramento Metropolitan Cable Television Commission is being videotaped in its entirety and will be cablecast without interruption on Metro Cable 14, the government affairs channel of the Sacramento cable system. Today's meeting is being cablecast live and will be repeated Saturday at 12 noon. A VHS copy is also available for checkout from any library branch of the City County Library. Members of the audience wishing to address the commission should fill out a speaker identification form located on the back table and give it to the secretary or clerk of the board. Please speak into the microphone when addressing the commission and state your name for the record. The address is not necessary. So we'll start right in. We'll have the clerk please call the roll.
Cox.
Present.
Pratt. Pratt.
Here.
Castanis.
Here.
Collin. Yee. Toby Johnson. Smith. For Toby. Dickinson. Panay.
Here.
Ortiz. Here.
Okay.
We have a quorum.
A quorum is present. You know, on all these boards, I can never remember if we salute the flag on this.
Traditionally, we haven't.
We haven't traditionally. The item number 1, would the clerk please read?
Brown Act update, review major changes.
Okay. Mr. Espasto.
Mr. Chairman, members, good afternoon. I'd like Commission Counsel Steiner to address this issue for you. I'm aware that you have had briefings in your other jurisdictions and other hats. We'd like to just bring you up to speed relative to aspects relative for us.
Good. Okay. Ms. Steiner.
Good afternoon. I'm going to try to do this very quickly because, as Rich said, I'm sure you've all heard this from your county councils or city attorneys. As you know, the new Brown Act amendments went into effect on April 1st. They make a fair number of significant changes. We did have a program which some of your staff attended and put together a booklet which is at the commission offices, and if they need more copies, we can get you more copies, and it goes in more detail. I'm just going to try to hit 5 or 6 high points. First, the Act now says that all meetings must be held within your jurisdiction, subject to certain exceptions, like reviewing real property that you can't bring to you. Your meetings have to be held in places that are accessible to handicapped and disabled people, in places that don't discriminate, and in places that are freely accessible where you don't have to pay money in order to go to your meeting, to the meeting. So that's sort of an overall clarification of the law. For the first time, the Brown Act specifically defines what constitutes a serial or seriatim meeting of the board. Those are the types of meetings where they're not held in a public setting, but where one member talks to another member who talks to a third member and a fourth member until you have reached a consensus, where a quorum has reached a consensus outside of the meeting. Those have been prohibited through case law for many, many years. The Act now defines exactly what a serial meeting is and prohibits that meeting. And we'll talk about that a little bit more in the next item on the grand jury report. The Act continues the what we've always called the less than a quorum exception to the meeting rule. In other words, all of your meetings have to be public and open, but if less than a quorum of your board gets together, that's not a meeting because you need a quorum in order to take action. The Brown Act continues the less than a quorum exception, but what it does is it modifies that exception now so that if you have standing committees that have a continuing subject matter jurisdiction or a set meeting schedule, even if that committee is less than a quorum of your full board, it is still subject to the Brown Act. Now, it's my understanding that the Cable Commission does not operate with standing subcommittees, so that while that's of great interest to many jurisdictions, I don't know that it's going to be of that much interest to you. There are expanded regulations for agenda descriptions, and you saw some of that on your agenda for today. There are changed findings to add an item to the agenda. So now if you wish to add an item to the agenda that's not on your agenda right now, the board would need to find based on a 2/3 vote, that not only did the need to take action come to the attention of the commission after the posting of the agenda, but also that there's a need to take immediate action before your next meeting. So you'll now have to make 2 findings instead of 1 in order to add an item to the agenda. The Act does specifically allow the commissioners now to briefly respond to public comments, to ask questions of clarification to the staff, and to refer items to the staff, and to direct staff to put items on future agendas. So that's something we sort of always did, but now the Act specifically allows the commissioners to take those actions. The Act requires now that there be public comment allowed on every item on the agenda, and that public comment has to occur either prior to or during the board's consideration of that item. So for every item on the agenda, there has to be the ability for the public to comment on that. And you've implemented that already, really, through requesting that people sign speaker slips and having the speaker slips go to the chair so that they can recognize them. One of the biggest areas of changes is in the closed session area. It's very, very complicated, and we're all going to have to try to get used to it together. The issues that you can go into closed session with have not really changed. It's still basically the same, litigation, personnel, real property acquisitions, labor negotiations, and the like. There's a requirement for more expanded disclosure as to what the closed session will pertain to, and you saw a little bit of that on your agenda for this week because you have a closed session on litigation. For the first time, there are requirements for reporting out of closed session the actions that are taken in closed session. Now, the reporting out requirements don't apply to every action that you take in closed session, but on a broad brush, basically, if you take a final action in closed session, if you're in litigation and you take a vote in closed session to approve a settlement agreement that is then final, you have to come out of closed session, report the fact that you finalized settlement on that matter, and report the voting tally of the approval of the settlement agreement. The same thing is true for real property acquisitions, for certain personnel matters, and for labor negotiations. So by and large, you'll be reporting out the actions taken and the voting tallies on those actions when you take final action on a matter in closed session. And as I said, we'll all have to work our way through all of these changes and keep tabs to make sure that we're complying appropriately with the Act. The one thing the Act did away with was the need for attorney memos for closed sessions for litigation. So you won't see memos necessarily in advance of your closed sessions that say this is a closed session in such and such a matter in such and such a way. Those are no longer required. But you will see additional information coming on your closed sessions to disclose information before a closed session and information that may be disclosed after the closed session. And with that, unless you have specific questions, I'm more than happy to expand on any of those areas. And as I said, your staff has the booklet we put together to try to hit more of the highlights of the changes, and you're welcome to copies of those if you would like.
Well, thank you very much, Ms. Steiner. Any questions for our legal counsel, Mr. Costanis?
Did you say, Harry, that we will not get memos in advance on topics dealing with the closed session?
You may still get memos, but prior to April 1st, the Brown Act required that if you were going to go into closed session on litigation matters, that you get a memo that specifically said this is a closed session pursuant to section 54954 point whatever A on pending litigation, and it lists the name and those of the action and those kinds of things. That specific memo is no longer required. A lot of that information you'll see on your agendas from now on. But I assume that as you hold closed sessions on litigation, if there's information your legal counsel wants to give to you to discuss in closed session, you will still get that information.
Okay, that's what I was concerned about.
Okay, thank you. Any other questions from members? All right. Well, seeing no other questions, is there any member of the public who would like to address this item? Seeing none, we'll move on to item 2.
Mr. Chairman, members, early last month, the grand jury issued a report with 3 recommendations to you. We have prepared, Commission Counsel Steiner has prepared models for you. Our intent today is to hopefully get your direction back to us to draft a response to the grand jury. That response would include regulations, statements, letters for your review and approval at the next meeting, that is at your May meeting. I'm recommending that you invite the public to comment formally, that is that you notice the hearing next month. With that, in order to try and summarize this, it's a fairly thick packet. We've included copies of the models that we'd like you to consider. I'm going to turn it over to Harriet in a second, but as I looked at the models and the analysis that Harriet prepared, there are several aspects of each model that you may wish to give us direction on. That is whether or not ex parte and this is in regards to the first recommendation of the grand jury having to do with ex parte communications. Recall they made three recommendations. The first one is probably the one that we need the most direction on. We believe there's a basis and adequate response for the latter two. First issue is whether or not ex parte communications would be allowed or not allowed. Second aspect would be what would be the triggering event, as how would you define an ex parte communication. Three, if you do define the first two, what length of time prior to the event would you consider having a report made, that is a disclosure of an ex parte communication. The next one is who reports. This is a very critical one. That is, will you as elected officials initiate the disclosure of an ex parte communication, or would it be your desire that the interested party make that disclosure? How should that report be filed and distributed? Should it be filed with your commission clerk? Should it be filed with your respective city clerk, board of supervisors, or clerk of the board of supervisors? Should it be released to the press? And lastly, within the parameters, what sanctions should there be if the regulations or your response to the grand jury is not complied with? With that, we have 5 models that Harriet's going to describe to you, and then what we seek is your direction on a particular model. As you'll see, that we have a sense that there is one model that on balance gives the best starting point. What we want from you is your direction to proceed on a model. Any refinements, specifics you'd like us to have, flesh out, and then bring back to you a draft response at the next meeting.
All right, Ms. Steiner, if you could please give us a brief description of what how you differ, how you look at the difference between legislative body. You've given it to us in writing here. Why don't you just give us an idea between a legislative body and a judicial, parajudicial body, quasi-judicial body, so we have an understanding of that.
I'd be glad to. You act as a legislative body when you adopt ordinances and laws that are of general application to everyone. So if you were to adopt a general amendment to the cable ordinance that would be applicable to all franchisees, all customers, whatever, that is basically a legislative act. You see that in your own jurisdictions when you adopt, let's say, an animal control ordinance that applies to everybody who owns animals. Those types of broad brush laws and regulations are legislative in nature. You act as an adjudicatory or quasi-adjudicatory body when you're acting more like a court, when you're taking your regulations and applying them to a specific factual situation and determining whether or not there either has been a violation of your ordinances or rules, or whether there's something that needs to, somebody needs to do something to come into compliance with them. So, for example, the transfer of control issue that's coming before you later today is more like an adjudicatory proceeding because you're applying your general regulation to the specific facts as they apply to Sacramento Cable. Your enforcement actions, where you think that there's been a violation of the franchise and you want to have that stop or have a hearing to determine whether there has been a violation, those are adjudicatory actions, and those are the types of actions where we get more concerned about having ex parte communications where only one party is there, than we do with legislative determinations.
Is a judge prohibited from having those types of communications during a trial with?
Yes.
But I understand a judge can have either
Are there more-
counsel
are there more
in his or her
slides? Do we
chamber
have some lights?
to talk about issues
Well-
of the trial, correct?
Not
What
without the
happens in
agreement
a
of the
court
counsel.
situation is almost all the time, if the judge wants to talk to one party, he talks to both parties at the same time, so that everybody knows what's going on and there isn't a communication from one side to the other. In the context of settlement negotiations, when the judge is acting to try to facilitate settlement,
Arbitrator.
they may have one party come in and try to get their story, and then another party. That judge who acts as the settlement judge will not then hear the matter if it comes before them, because they already are biased by having communications from only one side at one time.
Now, I'm just about clear on this from your legal definition of this. Just wondering, comparing the legislative body, the city council or the board of supervisors, in the instance of we're deciding on a particular, say, developer's plan, whether it moves forward or doesn't move forward, that's still a legislative decision?
In most cases, that's the rezoning, the general plan changes and rezoning changes are legislative changes. The more subsidiary changes, use permits, tentative subdivision maps, those types of things are adjudicatory. But historically, most city councils and board of supervisors have not been as concerned about ex parte communications on those issues because there's so much public notice that goes along with those types of activities. But those are still adjudicatory, and there are some city councils that I'm aware of that have rules where they will not speak to a developer who has a purely adjudicatory, just a use permit before them or just a subdivision map before them.
Well, members, the reason I bring this up is because I have not been able to find the real difference in the two. I understand the action if you take against a franchisee, that is, you're taking action against that franchisee. I understand that, but I haven't been able to connect how they're so different from a legislative body that we may act as a legislative body on the city council. And I'm still grasping to understand that. If, in my impression, if this is the case, then maybe our bodies, our legislative bodies, should be doing such a thing as well. I just try to be consistent in what I look at doing, and I can't see the consistency in doing it in this body and not doing it on the city council. But I guess that's our city council's duty to decide what ex parte actions are.
That's right.
But that's just my sense of it as I keep reading through this.
And I think this is an issue that has been getting more and more concern has been raised about this issue as time goes on. And you'll probably see more concern raised about this issue in the future in your actions as supervisors and council members. But by and large, more of what council members and supervisors do in your boards are legislative type actions. And the commission deals, while it also does legislative actions, more of what you do is more on the lines of enforcement or regulatory type actions. And so I think that's one of the reasons you see this coming before the commission now, where you have not necessarily seen it come before the city council and board of supervisors.
Well, even a zoning change proposal, for example, has some legislative character to it as opposed to adjudicatory, in the sense that the decision you're making is really what zoning to put on that land, which would persist whether or not that particular applicant, for example, sold the land. So it's not adjudicatory in the sense of determining once and forever the specific rights of a specific party. I see that as a distinction between that act and the adjudicatory acts that this commission often gets involved with, or the Public Utilities Commission, for example.
I think that's true, and the California courts have said that a rezoning is a legislative act.
I see.
So that's, again,
But it's still,
why you see the
I mean, let's not
differential.
beat around the bush here, people. It still means money for that person we're granting the entitlement to. It still means an enhancement to their property value. Whether they sell it on down the road really is immaterial in my mind. I understand what you're saying, that this party, it's going to be money for this party, that we are acting for or against, but I think the result is still the same, that this party could sell their franchise as well.
It's a continuum in that sense, because I mean, in theory, when you act upon a general plan or a community plan, you may be making decisions about land use designations that have economic implications for people.
Sure.
But certainly, and no one who's looked at this would consider that an adjudicatory act. They'd all consider that legislative in character because of its broad application. So I think you're really looking at a continuum, Josh.
Yeah, I'm just going beyond whether it's adjudicatory or whether it's legislative. I'm saying, what's the result for these parties that we're acting upon? And the result is it's going to cost them money, or it's going to save them money, or it's going to give them money. It's not so?
But the test isn't whether or not, the proponents or opponents lose money. The test is whether you perform a regulatory function versus enforcement. I mean, that's just...
I'm just trying to rationalize in my layman's mind to try to figure out, what, but not in a legal sense. I'm not trying to look at it.
We lawyers forgive you.
One of the other differences, I think, is when you're dealing in a legislative capacity, when you're doing a rezoning, for example, you can look at anything. I mean, anything that you know, anything that anybody brings to you at any point to help you make your decision. When you're acting in a more judicial fashion, you're supposed to be acting only on the information that formally comes before you as a body. And that is a real big difference between the legislative type action where you're looking at the whole world and making a regulation that affects the world, and you can bring everything you bring to that, you bring to that. And when you're acting more like a judge, you're supposed to only be acting on the information that's brought to you in your decision-making capacity, and not so much, not looking at information that comes to you from outside of that process.
But you have to admit, a judge reads the paper in the morning, right?
They're
so
supposed
he or
to be
she
trained so that they forget that when they come to make their
well,
decision.
I don't think all the training in the world is going to make that judge forget any item. But, okay, why don't we...
I find they forget what I tell them constantly.
Is that right? Well, it's a good thing you're on the Board of Supervisors
Or maybe it's
now.
just that they ignore it.
Yeah.
That's more
One of the things
Yeah.
you'll notice as we go through these is that we're not recommending that an absolute bar on ex parte communications. What we're recommending is that if there is an ex parte communication, that it be disclosed, so that other interested parties to the proceeding have a chance to know what happened and respond to that if they feel it's appropriate.
Okay. Well, any questions? Mr. Castanis.
Harriet, in that line, how about communications with those persons other than the cable company, for example, the grantees or our constituents? I mean, would there be quasi-judicial actions that could affect us where we would have to apply the same kinds of procedures that we're contemplating specifically with the cable company?
Yes, there would. Now, one of the issues that you'll see as we go through this is that you do a lot of different kinds of activities, and clearly you want to be able to talk to your constituency and not cut them off from asking a question. One of the issues that we can work on as we draft the regulations, if that's the Commission's choice, is what happens. It's one thing to have somebody come to you and give you a general comment. It's a different situation if you're in an enforcement proceeding and one of your constituents is going to be a witness in that proceeding, or if one of your constituents has a separate special interest in that proceeding, different from their interest just as a member of the public, then that person perhaps should also be subject to the ex parte communication rules. In other words, being new with the Commission, I don't know all of your history, but it's my understanding you have an enforcement proceeding going on right now that deals with whether certain customers were overcharged or not. If you decide not to talk to Sacramento Cable about that enforcement activity, then perhaps those particular customers who were overcharged, you also should not talk to about that particular activity. Now, that doesn't mean you can't talk to them about the larger world of cable, other things that you are doing, but they're more or less the opposite side of that enforcement proceeding.
Well, that was my question, the fairness of that, and whom we should speak to and whom we should not regarding that issue.
Well, depending on the direction of the Commission, I think what you should, if you decide to have an ex parte type communication policy. It should be a fair policy, not a one-sided policy.
Yeah. Any other questions before we begin the, okay.
Chairman,
Yes,
before you do,
Mr. Cox.
let me just comment. The difficulty that I have with the grand jury's report, and I've said this publicly and I want to say it again, I think the grand jury has made a serious mistake in their conclusion in this report. They did not, in fact, interview a majority of this board to determine any of their concerns or questions. I have difficulty with some of their conclusions. I also have difficulty with respect to each of the models that has been presented to us by our council with respect to ex parte communication. Has to do with the bodies that are appointed, not elected. And it seems to me that we all must serve in a capacity where we take the information and we make our decisions in public. That's what I tell the people who come to see me, that thank you for the information. We make our decisions in public. And it's interesting to me, and I respect those people who don't think they can do that. That's an entirely different situation. And if that's the case, I would encourage them not to meet in a private session one-on-one. I do not personally believe that recommendation number one makes any sense from the standpoint that we are elected officials. The grand jury, we're not required to have an ex parte communication. Legal counsel points that out, and it seems to me that if there are those who feel that they cannot make decisions objectively based upon the information presented, I understand that. I don't have that difficulty. And it seems to me that we are constraining this board when we don't need to constrain it. Frankly, we ought to be investigating the grand jury on why this report was issued. I call to your attention the grand jury's report, and I think we have excellent staff as well. But let me just read the general comments to this. On page 6 of the grand jury report, the grand jury reviewed the videotapes of the meetings, written correspondence, and reports in the course of conducting this investigation. Did not say that they had interviewed any member of this commission. I would have thought at least the grand jury would have had the courtesy, if they thought that there was a problem here, to interview either this body as one group or individuals as members. They then go on to say that the quality and caliber of the staff members employed by the commission and their record of efficient and effective administration of duties and powers delegated to them by the commission. I submit to you that I think we have a good staff as well, but you cannot, in fact, get that information from the material that they, in fact, reviewed. There are people who go to school for years to get masters and PhDs in order to determine effectiveness and efficiency of personnel. And then it goes on to say that good judgment and intent to carry out its mission with the assistance of quality staff support. I understand that we have quality staff support. And then it says the grand jury urges the commission to take steps to ensure this record is maintained. The bodies that they're talking about here are not elected. They are, in fact, appointed by elected officials. And it seems to me, while there may be some merit to the second and third recommendation, I think we send this back to the grand jury that says that as a matter of fact, we don't have to adopt an ex parte communication package. It says on page 3, Steiner says that the commission is not required by law to adopt a policy regulating ex parte communications. So it seems to me that in this particular situation, that at least the grand jury could have interviewed this commission individually or collectively before making a recommendation in the community that again puts us in a firefight where we may in fact not be guilty.
Well, thank you, Supervisor Cox. Any other statements or opinions from the membership on that? I would have to say that in some of what Supervisor Cox has said is true. I wasn't interviewed by the grand jury. I don't know how many members of this commission were, but it does seem to me that if any body, government body, judicial body, a group of people are going to investigate, it would seem practical, it would seem reasonable that they would investigate by talking to as many people as they could talk to. And if there is a way to send that comment back to the grand jury, I think it would be helpful. It would be helpful to make sure that the grand jury knows that at least 2 members of this commission were not spoken to. I don't know about the rest of you, if you want to make a comment on that, but I don't know if we can investigate the grand jury.
I suspect not. It was.
You suspect not? Well,
only from the 4th Supervisorial District could you investigate the grand jury.
Well, it's possible from the 4th Supervisorial District.
Well, this is the Cable Commission. That's the reason we can't do it. We can't do it.
But it does give me a sense that perhaps the grand jury focused their look at this commission with a very myopic eye that probably didn't go beyond a funnel. And if that's the sort of thing the grand jury does, that's what they do, I suppose. So until one of us is on the grand jury, that's the way we're going to have to live with it, unless the council can come up with a recommendation on that point to us.
I have heard similar sentiments raised by many of the public agency bodies that I represent. I'm not aware really of just about anything you could do with the grand jury short of going to the legislature and taking away their charter to do internal investigations like this.
Excuse me.
We have in the past, I have seen boards in the past direct comments to the presiding judge in charge of the grand jury indicating their comments that go along these lines.
Okay,
Mr. Chairman, let me just,
Mr. Cox.
let me just say that we do in fact have, we certainly don't have any investigatory ability. We do in fact have the right to speak up. This is still America, and we ought not to have our rights trounced on by a grand jury who did not take the time to investigate this, who reached conclusions without substantive information, and it just is not, it frankly is not right. And we need to alert the presiding judge to that matter, and we ought to publicly let the sunlight by the newspapers shine on this, just like everything else does.
Okay, Mr. Costanis.
Harriet,
I'll be back. I'll be right back. I have a point upstairs. I'll be right back.
My question pertains to what other action this commission could take. I was not interviewed by the grand jury either, and I was surprised at their report. Can you tell us what, you said that you've spoken, or you've represented other jurisdictions in matters like this. Is there anything that we as a body could do? Could we form a committee to take a look at these issues on our own, or ask some citizens to look at the same issues to give some balance to what appears to be a one-sided view of how we do business?
You clearly have the ability to do that. Your only obligation at this point, having received the report of the grand jury, is to make a response to the points raised by the grand jury within 90 days, which would be shortly after your June meeting. You can take the recommendations of the grand jury. You can tell them more or less anything you want to tell them about those recommendations. If it's the Commission's desire with respect to the recommendation on ex-parte communications to set up a citizens task force to look at that issue and report back to you, I think that you can make that your response to the grand jury and not take any particular action at this point on that matter, if that's your choice. If it's your choice to look at a policy and decide to go forward with some type of policy, that's also your choice. And as I said in your memo, while I don't think you have a legal obligation to have this type of policy, though at least in some circumstances that the board acts, especially in enforcement proceedings, I think that this type of policy is not a bad idea.
Okay.
I'd like to make a statement.
Ms. Collins.
I did take the issue to the grand jury in terms of providing materials because I was concerned about ex parte communication when so many millions of dollars are at stake and there is no disclosure by this commission. of members that they've had contact or we had no policy. And when I tried to bring up the issue of trying to even get the issue of having a policy or discussion on the table, the chair was instructed not to put it on the agenda by the majority of the people here. And instead, that if I wanted that kind of information, I could get it myself about what other kind of bodies do in a like and similar situation. So I did provide information to the grand jury. I am very familiar with the grand jury because they investigate the county every single year. They investigate the operating of our departments and make recommendations back and forth. I am not familiar with their internal workings or how that takes place. I know that we get reports and we respond to them. And certainly we don't have any choice in who's appointed onto the grand jury or in how much or how little they want to investigate. I personally am grateful for the fact that they gave us some information in terms of trying to make a distinction between legislation and regulation. I think we needed to hear it. And if you want sunshine, I think this commission needed sunshine on it. And I still feel we need to discuss these kind of rules. I do not understand why there is so much objection to even disclosing who they're having contact with during a period when we are supposed to be regulating. That is the resistance that I am hearing.
Okay. We have another question and comment from Supervisor Dickinson.
Not necessarily in that order.
Comment and question.
Comment and question.
Question and comment.
And then further comment.
And then further
Maybe,
comment, obviously.
perhaps.
And then further questions, possibly.
And then a storm of debate.
All right.
It seems to me that in framing the response to the grand jury, there are two elements here that have been raised. Really, one is in essence a process question, and the other really comes down to the substance of the response in terms of what, if any, action we would propose to take as a commission. There's nothing I know of that requires a grand jury to talk to anyone if they don't want to do that. I don't have any problem with incorporating into the response something that indicates that we wish they had interviewed members of the commission, or we believe that they might have achieved a fuller understanding of the issues if they had done so. That's fine, but in terms of how we respond substantively, it seems to me that's much more the germane issue here, frankly. Grand juries will do what grand juries want to do. And I've been in places where some pretty scathing reports from grand juries have been directed at agencies that I've known and worked with, and I've thought perhaps that those reports were completely wrong-headed and in error. You respond to them, you deal with them, you go on. The question is, how do you respond? And that's what we ought to be concentrating on in my judgment. That leads to my question. In terms of looking at the models that you have presented, Harriet, particularly the PUC model, you indicate that ex-parte communications, as I read this, with commissioners are permitted up until the time of submission of the matter to the PUC. Now, I wasn't, and then thereafter they aren't permitted until the matter is decided by the commission. I wasn't clear on that, and I was trying to recall from my days of dealing with the commission. Are you referring to ex-parte communications are permitted until the matter is actually submitted to the commission? In other words, as it goes through the administrative review with a hearing officer and the like, ex-parte communications are permitted with the commissioners. Once the hearing officer has made a ruling or a recommendation to the commission, that's when the ex-parte cuts off. Is that right? Isn't that?
That's correct.
Okay.
That's correct. It cuts off when the commission says, okay, we have the matter and we're going to make a decision now. So in other words, when they take it to themselves, that's when it cuts off.
Okay. I thought that was the case, and I don't know that and in some cases that might be a parallel for us, and in others not, because the matter is going to come directly to us. I would say this, that notwithstanding Supervisor Cox's remarks, and I certainly don't question the integrity of anyone who sits now or has sat on this commission, I think that there is an important element of the appearance of fairness and even-handedness that applies particularly to adjudicatory proceedings. And perhaps, I mean, this is something as lawyers we become more accustomed to dealing in the court system. But I think in that respect, and particularly given the nature of the work of this commission, while we're not appointed officials in the sense of the way by which we sit here, we're all elected and then appointed to this. The nature of the business of this commission is different than the nature of the city council business in general, or the board of supervisors. And in that respect, I think it does make sense to have a limitation on ex parte communication within a reasonable time frame of a hearing once a compliance matter comes up. I don't favor the member being required to report that. I think you just place a limit on the communications, period. And that's the approach that I would favor, and then you define what proceedings that will apply to. And I think that list is not that hard to develop.
Well, it looks like we've all thoroughly read the staff report, but if you would like, we could have an overview from council that may be a little more helpful, and then look at further discussion. Why don't we move forward?
Should we try to move forward?
Yeah, why don't we move forward? It looks like everyone's
helpful.
read it pretty thoroughly, but let's move forward through it. If we could have the lights, and then we'll look at this and see what we come up with.
Okay.
Electronics, they're coming.
Okay. Could you go to the next slide after this one? There you go. Okay. As you know, we put together several different models, and it's disappeared again.
It's disappeared. We've got to get the lights.
They turned the camera off.
Oh, okay. The PUC was the model that was referenced in the grand jury, so we started there. Under the PUC model, ex parte communications are allowed, but they have to be disclosed. So basically, under the PUC model, you can have an ex parte communication with a member of the Public Utilities Commission up until the point that the commission takes the matter under submission to make its decision. The PUC model applies to virtually all their proceedings except for rulemaking. So except for their legislative proceedings, it applies to everything else that they do. It requires that if there is an ex parte communication, that the person making that communication, the applicant, whoever's coming forward, has to disclose that communication, who it was with, and the substance of it within 3 days of the time the communication occurred. And there are reporting forms which they file with the PUC, and that information is published daily by the PUC. So if someone were to come to a Public Utilities Commissioner and have an ex parte communication, they would then fill out the form, submit it to the PUC clerk, and that would be available to the public in their publications. The penalty for not disclosing an ex parte communication ranges, and basically it's up to the Public Utilities Commission to determine what's appropriate. They have in the past had sanctions like dismissing an action, a request for a rate increase or something like that for a certain amount of time, and having it come back again. They may rehear the matter. They have a range of penalties. Their regulations don't have a specific penalty. So this allows it, but it requires the person making the communication to report that. If you could go to the next one. Okay. This is the California Coastal Commission. This was an ex parte rules that were enacted by the legislature. Again, ex parte communications are allowed for virtually all of their proceedings. It applies to almost all of their proceedings. But again, it requires that the ex parte communication be disclosed. And the disclosure has to occur within 7 days of the communication. If the hearing is actually within 7 days, then the disclosure has to occur in public at the hearing. And in this case, the commission member is required to act to make the disclosure, and he or she is required to file a memo with the commission disclosing the ex parte communication or disclose it on the record. There are provisions in this model to go to court, and the court has the ability in the appropriate circumstance to impose a fine not to exceed, I think that's actually $7,500, not $7,000. There's also a provision where a party who feels that they were damaged by the ex parte communication can go to court and ask the judge to find that that ex parte communication changed the result and order the commission to retract their decision and rehear the matter. So this one basically, again, allows communication, but it puts the burden on the commission member to disclose it. So we can go to the next one.
I'm a generalist.
Oh, okay. This is another model. The next two models, this one and the Air Resources Board, are more like the kinds of models you would get if you were in court. They prohibit ex parte communications with certain exceptions, and in this model, the exceptions are basically when when everybody knows what's going to happen. In other words, you want to have a meeting with a member of this commission, you have to invite the other side to come along with you. If you want to send a letter to a commissioner, you have to send that letter to all the other parties. Those are the types of exceptions that there are. So this is much more like a judicial ex parte rule, which says you can't do it unless you let the other side know what it is and you let the other side participate in it. And so basically, this one prohibits ex parte communications unless it's not an ex parte communication, unless it goes to everybody and everybody has a chance to respond to it. And there are no stated penalties, but it's my understanding that these commissions set the penalties as appropriate should there be an ex parte communication in violation of their rules. So can we go to the next slide? Okay, this one is the Air Resources Board, and it's basically the same as the OSHA, the Occupational Safety Board. Again, it prohibits ex parte communications except when everybody involved in the proceeding knows about and has the ability to comment on it. And so let's go just to the FCC one, which I think is the next one. The FCC, like most everything they do, it's very complicated. Their rules split their proceedings into basically three different classes of proceedings. Their rulemaking is not subject to the ex parte communications. Then they have a semi-restricted class where you can have some ex parte communication so long as it's disclosed. And then they have a fully restricted class of proceedings where there can be no ex parte communications at all. It applies not only to the commissioners but also to officials within the FCC, depending on what the type of proceeding is. And again, in the case where it is allowed, disclosure needs to be filed with the secretary, and that's published daily and available to the public. And again, the penalty basically varies on exactly what happened and what the circumstances are. So the range, as you see, goes from it's allowed but needs to be disclosed, or it's prohibited. And that's really the scope of the choice if you want to go forward with this kind of policy. The recommendation that we made in the memo is if you want to go forward with this type of policy, that you would allow ex parte communications but require them to be disclosed and place the burden of disclosure on the person making the contact and not on the commissioners themselves.
Yeah, but I guess
And so, questions or?
Okay. Any questions on any of these items of the description that we've heard?
Just one question.
Mr.
We could craft our own. In other words, we could take elements of all of these and mix and match.
Absolutely. We just gave you these because they seem to cover a range.
Right.
And we're looking for direction from you as to whether you want to go forward with this, and if so, what you want it to look like.
Did you find any legislative bodies like this, legislative judicial bodies who are elected officials, appointed, or do you see any distinction in that? Those are all appointed officials. The Coastal Commission could be elected officials. There are some city council members on the Coastal Commission.
I'm not sure exactly who sits on the Coastal
Yeah,
Commission.
there have been city council members. I think one local elected official has to be on.
Yeah.
So there is some, but legally you don't see any differences between elected and appointed officials?
I don't see that that's really the crux of the matter. I think the crux of the matter really is the adjudicatory versus legislative act. We did look through league materials to see if we could find a policy that had been adopted by a city council that seemed like it would meet your needs. There are policies, we didn't include them in here because they were they didn't really seem to speak to the issues that you're interested in. They were more along the lines of policy statements that dealt with, I guess they were much more amorphous type things. And they basically had policy statements, and some of them broke down certain types of activities that went before councils, but there really was nothing that we felt was would really show you the range in the same way that these policies do.
Okay. Any other question on this item? Any question of our legal counsel?
I would just like to, explore the ideas with Roger in terms of he made a statement that he would rather not have it allowed, and explore those options. And I would love to understand, the reasoning why you would want to go towards that model as opposed to a model that would allow but disclose, the way the staff is recommending.
I think Island may be a function more of profession than anything else. I mean, I think in an adjudicatory setting, I think it's just the simplest, the cleanest thing to do is to not have ex parte communications. It also ensures that everybody puts what they've got to say in the public forum, and that everybody hears it. And I think that it gets away from any concern of, gee, did they talk to me about this or did they not? That it's simply not a matter that's discussed. And I think I think most lawyers learn that line pretty well. I think that it's something that you're very conscious of, and in fact, if anything, most lawyers would be very careful to be very conservative about approaching that line. So you get a sense of it, and that makes it a pretty easy, bright line to adhere to. I also think that the approach of having discussions and then disclosing them, you get into a whole series of, well, what did that person really say? Who else should have been told? It opens up a whole area of additional investigation and questions that maybe just leads to more questions and debate than getting the issue aired substantively and resolved. So I think that's why I go in that direction.
Well, in the instance that was leading up to a lot of this discussion, I had made a unilateral decision as an elected official that because of the nature of the type of information that was going to have to be presented before us both by staff, so I didn't have contact with staff, nor did I have contact with the cable company during that time. It was a hearing we were going to be going into, and I just felt that I should not. So I'm not saying I'm against not allowing, the ex parte communication. I think not allowing that at all is a good idea. It would seem to me what you would have to do under those circumstances then is spell out under what circumstances that you do or do not allow it, at least as I read the memo. And that is an approach that we could take. I took it for myself because I really felt that I owed it to the people that you represent to make sure everything gets out on the public hearing, and that everything that's said is said publicly, so that you're not being influenced by something that might have been said to you privately but will not be disclosed publicly.
Okay. A question from Ms. Ortiz.
Yeah, I have just a question in terms of clarification as to at what point is the trigger or under submission, at what point does that occur based on, I forget the prior model that was used to trigger?
Under the Public Utilities Commission rules, as I understand them, the ex parte communication is prohibited once the commission takes the decision to itself. And so, for example, let's go back to the courtroom just because it's an easy example. A judge will hear evidence and keep going on and listen to the lawyers on both sides. When the judge says, okay, it's under submission, I'm going to make my decision. Okay, that's, I think, what the PUC does. They, as it's going through, you can make ex parte communications, but once the PUC says, okay, now it's time for us to make a decision, that's when the cutoff is.
And the reason I ask that is that
Much more than was before.
even though we are contemplating whether or not to adopt a policy regarding ex parte communications, I just want to be clear that in the prior instance when we that raised this issue, that triggered the grand jury investigation, we had not yet reached the point of being under submission, at least in terms of our regulatory function at that point.
That's absolutely true.
Okay.
That's true, and I think it's important to point out that distinction in that case.
But it
obviously, we were being lobbied not to take it under submission.
Good. But legally, whether we do or do not adopt a policy, we were even at that point not at the critical juncture. I just wanted to clarify that.
You would not have been under the critical juncture under the PUC rules.
Okay.
But that doesn't mean we couldn't adopt rules that were different from that.
Correct. We can adopt something that's even more conservative, but I just wanted to clarify for the record, to the best of my recollection, we weren't at that critical point based on our regulatory function at the time the issue arose. But it's good that we are raising it now.
Okay.
Part of your discussion can focus in or can bring in the issue of the triggering event. As we've discussed, many of your decisions are legislative. Triggering events, in my mind, would include a noticed enforcement action, and I believe we've had 2 in the last 4 years, would include a noticed rate determination, and possibly a noticed adoption of regulation. And those might be the 2 or 3 categories of triggering events. All told, you've probably had, including regulations, maybe 6 or 7 of those on your agenda in 10 years.
Did you want to? I have a question of Ms. Collins.
Yeah.
Ms. Collins, maybe you can describe for me your impression of the difference between when you make a legislative action on the Board of Supervisors and you have, say, developer A sitting in front of you wanting to rezone agricultural acreage, 1,000 acres, to single-family homes. And you obviously speak to those people beforehand. And so I need to know from you. Excuse me? Sometimes you don't. But I need to know from you so I can understand this rationale, because I'm on the verge of just saying there should be no communication. And it should be for legislative actions as well. And I think we should stop fooling ourselves. And I ask you, since you're a non-lawyer on the panel, I've gotten the legal explanations on both sides of me and in front of me.
And you'll get the bill.
The bill too. But I haven't been able to understand it from kind of the layperson's viewpoint. I've gone over this in my mind, and I just can't see the real difference. And I can't rationalize in my mind not allowing one party to speak to me that 4 of us on this body or 5 of us on this body has jurisdiction over, and then in another instance we can talk to them. I don't see the difference.
Okay, I see a really big difference, a huge difference to me in the terms of the legislative decision that you have to make. To me, and now our county council's always told us that's not an entitlement either when you're talking about general plans and zoning. That's not an entitlement. Entitlement comes much after that. So you totally are able, as far as I'm concerned, to make a legislative decision. In terms of a regulatory decision where what you are doing is triggering enforcement actions, where you're called upon to exercise that kind of discretion, to me, that is more a quasi-judicial setting where you really have to look at the evidence before you. It's more evidential. You've got to have an evidentiary record before you, and you make a decision based on that and what is in that record, and it's on that that you can be sued over, etc. You could make a legislative decision regarding zoning, and it would be rare for the developer to sue you over denying them.
But so your point is based on being sued, or?
No, I'm just saying there's a distinction I see as a layperson between a regulatory action regarding enforcement and the type of actions that you take when you're being lobbied and listening to things in public hearings. I will tell you one thing, that I meet with all kinds of neighbors, I meet with developers, I meet with people on all sides of issues. If I think that I have been told something by any of those parties that is really influencing my decision that they've not been willing to put in the public record, I will say it. And I will disclose that as one of the things that's influencing my decision making, and let the people have an opportunity to refute it. But I still think that's a legislative action. I think it's very different when you're in a regulatory mode, and so I obviously would be very much in favor of having rules in this regard under which we operate as a commission in order to do away with any feeling out there that we are being unduly influenced by the franchisee.
So let me ask you another question then. You don't believe, as legislators in our respective jurisdictions, that we are being influenced when we meet with people beforehand?
I think we're listening to them, and
So then, let me ask you this then. At that point, if we're listening to them, and now you're in a...
We're not taking evidence.
We're not taking evidence.
No. When you're in a hearing process here, you're taking evidence. When you are listening to people make arguments in an enforcement action, you are, in a sense, taking evidence. That's how I see it as a layperson.
Well, okay. I'm still grasping with this. Mayor Pratt.
You don't need to have evidence to make a decision on
legislative
a general
decision?
plan change. No, on a legislative decision.
Even though it could mean millions of dollars, even though it could mean millions of dollars for this franchisee or another franchisee, we're all talking...
It's not the dollars that's
it's not
important.
It's not
a different distinction.
the economic benefit that can be derived by these actions.
No, you're not talking. You're not really looking at what the economic benefit of it. I think Commissioner Collins said, when you do a rezoning or when you do a legislative act, you're looking at the whole world, and it doesn't matter what you make your decision on.
Counsel, I'm speaking specifically to one person sitting in front of us, and the decision that our body makes will say whether that land becomes something more valuable. And that isn't the whole world. I'm not talking about a general plan. I'm not talking about a specific plan. I'm talking about a piece of property coming before the council or the Board of Supervisors or the council in Galt.
But the courts have said that whether you're rezoning one particular piece of property or rezoning half the city, it's still a legislative act.
No,
I understand that it has a really big impact on the property owner, whether you say yes or no. You know, and it has an impact on the neighbors whether you say yes or no. But it's, at least when lawyers look at this, they don't look at necessarily what the impact is. They look at the process and what the process should be. Okay. And in one case, you're looking at a process that's very open. And in the second case, you're looking at a process that's based on evidence that comes before the board. And I think that's the essential difference, not really what the result is when what the monetary impact is to the person that's asking you to do something, or the monetary impact of a person that you may be enforcing an ordinance against.
I see. Okay, Mayor Pratt.
Well, Mr. Chairman, I want to say that I agree with your position.
Well, I don't have a position yet. I'm trying to grasp at a position.
The position not to speak to anyone ever you know, if that's your position. I mean, that's involved in.
Well, that's what I'm coming to that position, and we should do it on our legislative bodies as well.
Well, in this instance, you can tell by the dialogue that's going on here that the entire matter is gray. I haven't seen anything that's become clear in my mind yet. We have to explain everything we do, and that's subject to yes, you did, no, I didn't kind of dialogue. And I think the only really clean-cut thing we can do is to say we won't have any conversation with any of the cable company personnel.
Or any of the cable companies. Okay. Yes, Councilmember Ortiz.
Not willing to go with that.
If it's possible for us to either to come back with a definition of legislative versus quasi-judicial, that might be probably easier rather than have this debate. But I think we also have to keep in mind that we have an obligation to our constituents in our legislative function to be responsive, and that means that we need to be able to provide access to those constituents in our legislative function. I agree that if we are going to adopt a policy that that there should against ex parte communications, I don't have a problem understanding the distinction, and again, I hope that we can come back with that distinction and definition to make it clear. But we may want to, rather than talk about a general prohibition against any contact, factor in our obligation to have an open door policy, to listen to our constituents that elect us or that have an interest in our districts, and that is an obligation and a function of our legislative capacity. Once we get that clarification what the two roles are. And it may help, Mr. Panay, to keep in mind that when you are in an adjudicatory or a regulatory mode, there are very specific rights that either are lost or conferred as a result of some determination of fault or violation. When you're doing a zoning, rezone, there isn't an imposition of rules that say you've either done something or not done something to adhere to. So rather than look at it as a right that might monetary loss, I mean, try to think about there are rules, there are laws, and we play the role of weighing the facts to determine whether or not certain rules or laws or regs have been violated. So that's a distinction somewhat in the way I look at legislative versus regulatory.
Mm-hmm. Okay. Thank you. Any other questions, comments from the commission? Yes, Mayor.
Let me correct my statement. I didn't mean to say that we would not communicate with anybody. I meant that we would do it in a public forum,
Okay.
I have a question of
Yes, Mr.
Harriet. We're regulated by the Fair Political Practice Commission, and you did not use they don't have a model, they didn't recommend anything, why don't we follow what they say?
I don't know that they have an ex parte communication rule. I'm trying to remember if I looked or not.
Who's that?
FPPC.
The FPPC.
We all must adhere to their regulations in terms of reporting conflicts of interest and contributions and all of those things.
I'm sorry, I don't recall. I mean, I know we went through a stack of these things and tried to get ones that made the most sense, but sitting here right now, I cannot remember whether we looked to see if the FPPC had an ex parte rule. My guess is if they do, it applies to their enforcement actions and not their rule setting. Because that's it. I mean, the FPPC, as you know, has two clear functions. They adopt regulations to implement the Political Reform Act, which apply to everyone, and then they enforce those rules if one of us screws up. And I think in their enforcement proceedings, they do have, they use hearing officers sometimes, the full commission at other times, and they probably do have some type of ex parte rule, but sitting here right now, I couldn't tell you what it is.
Okay. Very good. Is there a motion on the floor?
Mr. Chairman, I'll try a motion. We'll see how far it goes. I would move that the staff prepare a response. You can bring it back next month.
Yes, sir.
A draft. I'd move that the staff prepare a draft response to be presented at the next commission meeting that reflects the consensus of the members as expressed
Oh, that's very funny, Roger.
All right, now on for the real motion, Mr. Dickinson.
Yeah, but you should have seen the look on his face.
There's great consensus here.
A draft response which reflects the comment that we as a commission believe that the grand jury's analysis would have been enhanced by interaction with commission members. Firstly. Secondly, that we adopt a position of defining classes of adjudicatory and legislative actions into which actions of the commission would fall, that the staff recommend a triggering event for purposes of communications with commission members, and that we adopt a policy of not permitting ex parte communications on adjudicatory matters once the triggering event has occurred.
Second.
Oh, wait.
Okay, how does that?
Do you want to add something?
You want to add something?
And also a determination or a definition of the burden of disclosure.
If you aren't going to have the contact, you shouldn't have anything to disclose.
Well, there's no contact, so why would there be?
Why there would be no disclosure?
Well, I understand your point.
Yeah.
Well,
Because there may still be contact even though you prohibit it, and you want it disclosed if there is.
Yeah. Okay.
Well, if there is.
Well,
if it's a penalty.
If it's a penalty, if it's a violation, then you'll have to find out about the contact in order to penalize the party. But I mean, if you're breaking the rules or the law or whatever this is called, I don't think you're going to be disclosing it.
Okay.
So how do you catch the person if they are doing it?
Good question. Or maybe just
Well,
require some.
Yeah, maybe we could work on something to bring something
Let me
back
add.
along
Let me
those
just
lines.
add to the motion that there be a staff recommendation on that issue of reporting any ex parte, otherwise prohibited ex parte communications, and any penalty structure attached to that. All right.
Accept that. Okay, I'll accept that.
So that's it's been moved and seconded. Would the staff like to repeat that motion?
I'm okay, are you? We've got it down. I think we're okay.
No,
Okay.
yeah.
Understanding was,
So we know you have it down. No.
what I heard, and correct me, Diane, is Mr. Dickinson's motion was that staff prepare a response which reflects or informs the grand jury that the report would have been enhanced had there been more interaction with commission members. And further, that the staff prepare a draft and report back to you next month, which defines classes of actions which would be adjudicative. And by definition, the ones that would not be in that class would be legislative. That staff give you a recommendation, I think it's part of the same statement, of the triggering event, and a policy which would say that there would be no communications after the triggering event. Then you left open to staff a recommendation on disclosure if there were to be a triggering event, or excuse me, were to be a communication, and any sanction or enforcement provisions. You left that part open.
Yeah.
I have a question.
Let me just say that I think you need ex parte communication with exceptions. For example, if you ask the other side, is it okay if I talk to the commissioner, and the other side says, fine, go ahead.
Well, in the case that we had before us, who would have been the other side?
Well, the difficult part in a lot of your proceedings is that the other
don't know.
side is the consumer, and they don't have
Right.
a representation.
And that's
They
effectively
don't
what
have
We
it.
are the representatives of the
Right.
consumer.
So it's,
So would you have to ask permission of the commission? Is that what you're?
No, I think effectively you're going to not know who the other side is in its entirety, and so you can't have ex parte communications.
One of
Well,
the
we might as well
models
not
that
put that in.
that they discussed in here, though, it was in terms of having, you could request to have staff present. You talked about who you could have present, and that's one way to get around it.
Yeah, I wouldn't do it. I would prohibit
say
ex parte
prohibit it.
communications.
That is your motion, to
Yeah,
prohibit.
Yes.
Yes.
To prohibit ex parte communication.
Right.
Mr. Costanis.
My question pertains to the triggering event, and when possibly, Harry, we would be notified. For example, I mean, is it when the agenda is published? Will we know in advance, 6 months, 2 weeks in advance, or I mean, when do we know how this is? And the second question is, I'd hope that the agenda would be marked, maybe a red X somewhere where it's a danger zone or something. I don't know.
Yeah, I think the way we would, I need to talk to Rich and get more familiar with, your proceedings, but clearly, like putting something, when the agenda gets published with that item on it, that may be the triggering event, and so you would get the agenda and you would then know that. To the extent that you direct staff, for example, perhaps to institute an enforcement action, that direction or the actual institution of the enforcement action may be the triggering event. So I think we'll have to work on that and bring something back that's clear enough that everyone can understand. If it's not clear enough, then we'll have to go back to the drawing board and do it again.
Okay, well, oh, you want, yes, Mr. Purcell.
You thought I wanted to do on legislature too.
Yes,
Mr. Chairman, I just want to report in as the alternate for Supervisor Cox voting on this item.
Yes, Mr. Purcell, you will be the alternate voting for Supervisor Cox. Okay. The clerk, please note. Yes, any other questions? No other questions. Is there any testimony from the audience on this item? Okay, no public testimony on this item. Seeing none, we have a motion by Supervisor Dickinson, a second by Supervisor Collin, and the clerk, please call the roll.
Pratt.
Aye.
Castanis.
Aye.
Collin.
Yes.
Dickinson.
Aye.
Panay.
Aye.
Smith.
Aye.
Purcell.
No.
Motion carries.
We forgot Ms. Ortiz.
I'm sorry.
Just for you.
I put my finger right on it. Ortiz.
Let me make it.
My apologies.
Okay, yes.
Motion still carries.
Okay, the motion is carried. We'll move on to item number 3 on the agenda. If the clerk would please. Yes, ma'am.
There were two other recommendations of the grand jury.
Yes.
Sorry to bring these up.
I guess we're not going to move on.
The second, basically, our recommendations to you was that your adoption or starting to adopt an ex parte communication rule responded to the grand jury's recommendation number 2, which was their concern about seriatim meetings or serial meetings under the Brown Act, which we all know are prohibited and which none of us do and have not done for many years, but they were concerned and wanted more to know if the commission wanted to adopt more stringent rules about meeting with constituents. And our feeling was that the ex parte rule would respond to that recommendation as well. If that's the commission's sense, then we would go forward with that recommendation.
Yeah, I think it will.
Move staff recommendation.
Second.
Moved by Mr. Dickinson, second by Ms. Collin. Any public testimony on that motion? Any questions from the commission? Seeing none, will the clerk please call the roll?
Ortiz. Aye. I think I missed that one. Pratt.
Aye.
Collin.
Yes.
Dickinson.
Aye.
Smith.
Aye.
Panay.
Aye.
Purcell.
No.
Motion carries.
Motion carries.
Castanis?
Oh, no.
Maybe I could be first now.
Oh, glasses. Glasses. Castanis.
Aye.
Ms. Castanis is an
Motion
aye.
carries.
The motion carries. We'll
And
go. Yes.
The third recommendation of the grand jury had to do with incompatible activities where for some reason they believed that this commission was not subject to the incompatibility of office provisions. It's my opinion that you're already subject to the very laws that they were asking you to become subject to. And so my recommendation on recommendation number 3 is to tell them that you're already subject to the incompatibility of office provisions and let it go with that.
Move staff recommendation.
Second.
It's been moved and seconded by Castanis, second by Collin. Any member of the public would like to testify on this item? Any question, statements from the commission? Seeing none, the clerk please call the roll.
May I ask a question first?
Question?
Do we also need a motion to schedule a public hearing? Do we want to take care of that with
Thank
this
you, Matt.
motion?
Can we incorporate this as well?
The
was item
the
one.
maker will accept
Yes.
that May 5th will be the public hearing on this item. The 2nd will accept that, Ms. Collins. So that will be included in the motion. Thank you.
Thank you.
Would you please call the roll?
Pratt.
Aye.
Castanis.
Aye.
Collin.
Yes.
Smith.
Yes.
Dickinson.
Aye.
Ortiz.
Aye.
Purcell.
Aye.
Panay.
Aye.
Motion carries.
Castanis, get on there. Okay.
Yeah, I voted Ross, thanks.
Okay. Item 3. Will the clerk please read?
Sacramento Cable Television affirmative action presentation.
Mr. Chairman, at your last meeting, you directed staff to coordinate with the city's affirmative action officer in regard to a broad review of the Sacramento Cable Television's affirmative action plan. I've met with Mr. Fleming. We've corresponded. He asked the Sacramento Cable Television make a presentation to you today in public on the status of their affirmative action plan and efforts, and from that he will proceed with his review. With that, I recommend that you invite Sacramento Cable Television to take the podium.
All right. This is an item that I had requested last year, and a couple of other members requested, Ms. Collins, and so we had some scheduling problems previous, and so why don't we move forward with it.
Good afternoon, Chair, members of the Commission. My name is Dave McVicker. I'm Director of Human Resources, Sacramento Cable, California. And I appreciate the opportunity to come before you today and talk about the Affirmative Action Program. Relative to Mr. Fleming's letter, two components, I think, without attempting to make it too oversimplified, I'd like to go into exactly what goes into making an Affirmative Action Program, the approach Sacramento Cable takes, as well as once a candidate is recruited, in turn, what are the in-depth training programs that we have in which to try to develop and also promote that individual. Basically, the components of a successful Affirmative Action Program can be best expressed in an acronym: preparedness, being implemented once it's developed, and also follow through. As far as the program that we have at Sacramento Cable, it covers a vast array relative to the in-depthness that goes into the recruiting process. In human resources, and in the many years that I've been doing it, I've had the good fortune of representing several companies and major firms. And I must say that the Affirmative Action Program is one that is a very important tool relative to recruiting and a successful recruiting process. Affirmative action is nothing more than, as a service organization at Sacramento Cable, our intent is to mirror the community by which we serve. And we do that through the members of our organization and the cultures to which they bring to that organization in developing it in its success. To go over some of the components that go into the Affirmative Action Plan, you have to go into and look at what is very much, or is clearly known as an MSA. An MSA is an acronym for Metropolitan Statistical Area. And that area is one in which we draw the data of those people that are capable or in the given recruiting area to which could secure jobs for an organization. So in turn, our MSA that we use through the FCC is the Sacramento area. We go much further than that, though, because we have categories of respective employees that we're responsible to identify and categorize, such as officials and managers, professionals, technicians, sales, clerical office, and so on. These respective people are also categorized from the MSA, and it gives us a threshold by which we measure, as an organization, our successes in recruiting and developing individuals. I'm very happy to say that given the statistical area that we serve in Sacramento, and I'll have some handouts for each of you, are that the breakdown of the statistical area is one whereas we have 53.7% male, 46.3% female. Minority breakdowns are African American, 5.5%, Hispanic, 10.4%, Asian, 6.3%, and American Indian, 1%. How do we measure against that respective MSA? Well, the first thing you have to recognize is that these respective statistics are raw material based on the last 10-year census. This data that I just reported to you is from the 1990 census. And in turn, when you use 8 principles that go into turning the raw data by weighting it so that you can, when you're recruiting for a particular job, you weight it in a fashion so that for one particular job, such as clerical or office support, maybe those candidates would be in the immediate area, such as within a 15-mile radius. Whereas officers and managers, you may extend a recruiting area to extend clear into the entire state of California or the western United States. But for purposes of the MSA, Sacramento Cable's workforce compares male 61.9%, females 38.1%, African Americans 15%, Hispanics 13.8%, Asians 5%, and American Indians 0.5%. As far as another thing that as an organization that's very concerned in developing a diversity in its workforce is one that you have to make sure that you are attracting candidates so that they can be considered for application for joining your organization. As far as the statistics relative to our application flow for 1993, we had 59.2% male candidates, 40.8% female candidates, 16.4% African American candidates, 10.1% Hispanic candidates, 5.1% Asian candidates, and 1.7% American Indian candidates. As you can see from that, there was enough application draw so that we could start working towards achieving the original numbers that I had stated earlier. Our hiring ratios for the year of 1993, we found we were very happy with. And some of the lengths, I think, that as a concerned employer, not unlike any major employer in Sacramento, goes into recruiting. That recruiting process is not just an advertisement in the paper. As far as the actual recruiting process, it's done through becoming involved in the community, using the minority agencies and respective representatives in the MSA area so that you can draw minority candidates, as well as female candidates as well. With the hiring ratios in 1993, the male candidates 60.5%, female candidates 39.5%, African Americans 12.9%, 15.6% Hispanic candidates, 5.4% Asian candidates, and 0.7% American Indian candidates. As you can see from, and I know you can't see since I haven't presented it to you yet, you will see that the one of the areas that we are concentrating on is that we know that our Asian respective utilization is not up to the MSA. The original MSA is 6.3%, and we presently in our organization have 5%. But we were successful in recruiting and successful in hiring 5.4 of our candidates last year as being Asian. So we're working to improve on that 5%. To give you another idea of some of the other efforts that we made during 1993.
At that point, let me just see if there are any questions up to this moment. Ms. Ortiz?
Yeah, I just want a little clarification. If it would be helpful, actually, if you do have documents for us to see, because we're frantically trying to mark these numbers down.
Maybe we could have the clerk pass those to us. Thank you.
In my effort to write down some of the statistics you were giving us, you mentioned your MSA percentages versus actual hired, and you acknowledged that you had a deficiency of roughly 1.3% for your Asian
Thank you.
hires versus the MSA. Is that correct?
That's correct. We had...
But let me just finish.
I'm sorry.
So if I heard correctly, we actually have a larger deficiency regarding the African American hires at negative 5.5%.
No, that would not be correct.
Okay, let me recite your numbers then.
Fine.
5.5% African Americans hired?
No, that's the
No,
metropolitan
that's in the-
statistic area.
That's
Okay.
what was not clear.
I'm sorry.
Okay.
So this is in the MSA.
Okay, good. So relative to our African American hires and our Latino hires, are you either at or above your MSA numbers?
We're 3 times.
Okay.
in
And
the
what categories are those in?
African American.
I mean, in terms of entry level, proportionately entry level, professional,
Right,
staffing levels?
I'll go through those in just a second.
Okay.
Okay? I wanted to lay the basis, if I may.
Okay, go ahead then. I'm
as to
sorry for
explaining
Okay.
what-
Any
What
other
help?
questions up to this point? Okay, why don't you move forward then?
Fine. The efforts in 1993 relative to our recruiting process were for those jobs that we had open. We had approximately 147 opportunities at Sacramento Cable.
Out of how many opportunities, sir?
47.
Sorry?
147 total is...
Total, that's correct. All right. Of those, and I'll break down the categories, hopefully this will answer Ms. Ortiz. We had 5 officer managers positions open in 1993. All 5 were filled by females. 2, representing 40%, were filled by minorities. In the professional category, we had 1 opportunity, of which it was filled by minority female. In the technical side, we had 4 opportunities available, of which none were filled by females, but all 4 by minorities. In the sales department, we had 31 opportunities, 7 of which filled by females, 7 of which filled by minorities. I think a keynote here is something that has been facing us as an employer here in Sacramento, is that we've had difficulty in securing female candidates in the direct sales category, simply because it's an uncontrolled environment, one in which we cannot guarantee as an employer when they knock a door who may be on the other side of that door. And we've been unfortunate in not being able to entice candidates, and especially female candidates, in which to take that opportunity. February 10th, we were successful in locating 5 candidates, female candidates, at the diversity conference. All 5 were offered jobs. All 5 turned them down relative to direct sales. So it's a concern. And we will continue to attempt to increase our utilization of females in that category. But I would be remiss in, if not bringing that forward to the commission, in saying that if you offer someone a job, you can't make them take it.
Could I ask one other
Yes,
thing
Ms.
about
Collins.
the sales? On the sales also, is it an employment position or is it a commission position?
It's a strict commission plus bonus.
Say it. Okay, so for many single moms, that's also a problem.
That's correct.
And you know, so they're not, because they're not considered. If it's on commission and bonus, does that also mean there are no benefits?
No, ma'am. Full benefits.
So there is a full benefit package.
Yes, ma'am.
Okay, so that's paid regardless of the commission
That's correct.
approach. Is there a salary in it at all?
There's only a training salary initially to get them through their orientation and being acquainted with the cable service.
One of the reasons I'm asking those kind of questions is that we did have a conference on women in non-traditional jobs, and I wasn't sure how much of the other jobs you had is non-traditional, but you certainly have a deficiency in terms of female hires. And it would seem to me that you know, I would just like to get at maybe what are some of those problems in terms of seeing if they can be overcome.
I see.
And
We have been...
because there must be
working,
other non-traditional areas.
Yes, ma'am.
Yeah.
We have been successful. I've been working with Heald Institute on the technical positions. In fact, their graduating class was yesterday, and they submitted resumes for my attention for technical and operative jobs in the hopes of selecting candidates that may be female. So we are
What are those
aggressively-
technical type jobs?
Service technicians to the home.
Okay. So that would be it. It would be the service technicians to deal with the converter boxes, et cetera.
That would be correct. And also in the operative jobs would be the installers themselves or audit techs. Yes, ma'am. On the office clerical, we had 78 positions last year. 45 were, or 58% were filled by females. 30 were filled, representing 39%, by minorities. On the operative jobs, we had 25, which we were unable to fill with any female candidates. 28% of those were filled by minorities. And on the labor side, we were unsuccessful at filling with any female candidates and one minority candidate. One thing that we have seen as well in addressing Ms. Collins, or Commissioner Collins' comments, is we're seeing a migration of your concern there of a single parent, for instance, where if they want a more controlled environment, they will promote over into the customer service side, where it's a more traditional type of work environment. And it too is, there's a base along with the commission there. All right?
I will try to see that the programs that are being done by, which SETA is a part of, and there's women in non-traditional employment type forums that are going on, that as an employer, you get invited and perhaps brought into that process.
Thank you very much.
Do you have the numbers that you were just giving us in a form that can be distributed?
I do in a former document, Mr. Dixon. I will surrender that to Rich as a full and complete affirmative action program for 1993. And in turn, if you'd like, I'd be happy to supply you with copies.
I think members of the commission would appreciate that.
I'd like to take a moment, if I may, and introduce Carolyn Prince, who is our training manager, and possibly she can give you some insight as to the training that goes on once a candidate is selected and identified and offered a position with us.
Before you do that, do you also have numbers for the current composition of the various categories of positions that you've been telling us about? You were just telling us about the distribution among hires last year. Can you give us?
Yes, sir.
Or is that part of the report already?
That's all encompassing.
Okay.
That's correct.
All right. Anyway, if there aren't any further questions at this point.
We get it?
It'd be interesting to see what they take care of.
Good afternoon to everybody.
Good afternoon.
I'm Carolyn Prince, and I'm currently the training manager for Sacramento Cable. The training that we provide for our employees pretty much falls into four categories. First, it would be the skills that they would need in order to do the job. Obviously, the hiring would be directed toward people with bringing in some of those skills already, but to tailor them to fit the company. And then we're doing a number of things which would really be under the personal growth category, such as financial planning, based on helping people understand our 401k plan and letting them choose how they would want to utilize that. We do a series of lunch and learn that give people an opportunity to come in during their lunch hour and hear topics such as, you know, how to deal with your 2-year-old when they're screaming on the floor, and other topics related to that, wellness issues. We do a health fair. Then there are more of the interpersonal kind of skill that we develop in communication. And then the professional development, which would be time management, delegation, and some of those things. In the little over 3 years that I've been in the position, I've seen a concentrated effort on the part of Sacramento Cable to increase the training opportunities for all of their employees. There's never enough training. There's always more that you can do. There are things that you look back and you maybe wish you had done. But I do believe that in all honesty, we are trying to cover all the bases to the very best of our ability. The incoming training process is quite extensive. to prepare the person in that introductory period for their job, to groom them for success if at all possible. And we have within most of our departments levels of progression within the department. And then also we are currently launching a program which is more under the mentoring category, taking some of our people who would possibly be future managers within the organization and putting them on a separate course of leadership development and learning. Again, I'm open to any questions that you have.
Are there any questions, members?
We would be happy to answer them.
Ms. Ortiz?
Do any of these in-house training programs, I assume for promotional opportunities, you mentioned the bring your lunch and sort of take your lunch time to learn this. Do you actually have paid during working hours programs that don't require non-paid time or time outside of the regular work day?
Very, very much. We use outside consultants coming in for training. And when we send someone off-site, that is also, of course, paid time.
Okay, not having that information that I know is going to be provided to us eventually, have you established any sort of targets or goals? And again, I kind of getting at what Commissioner Collin was trying to reach, but particularly for women of color, I suspect that the entry level, it's like many other areas of women of color, if they're in your operation, they're generally at the entry level. Have you established goals primarily to attack the most aggressive of problems internally in that document that we may be seeing soon?
Yes. Yes, we have. And in fact, relative to that, on your statement, women of color, many of them join not at entry levels. We have been successful recruiting them into supervisory roles with us, as we have other people of diverse backgrounds. So, you know, I guess, you know, I'm sensitive to it in as much as I do this for a profession, and that I think many times it's easy to stereotype, you know, possibly where one may enter an organization. But in fact, we are very proud of the respective relationship that we've had with developing a very diverse workforce, and one in which that when one may come to us, we do believe in promoting from within. And in fact, some of the deficiencies that you will see from this document will be ones that are from specifically from promotional considerations.
I believe you based on what little information we have, but could you tell me how many women of color are in your executive positions?
Yes, ma'am, I can.
And what the total of your executive positions are?
There are a total of, office and managers, there are a total of 51.
Office managers?
That's correct.
And you consider that a professional? Okay.
No, office and managers. There's a separate category for professionals.
Okay. Now, what do you consider your executive level positions?
Okay. Office and managers are your supervisory, up through management, directors, and general manager.
Okay, good.
And there are 51 of those positions?
There are 51 of them.
Okay, good.
19 of which are female, 8 of which are women of color.
Okay, so that's 8 out of 51.
And what's the further, do you have the categories there for additional classification?
Yeah.
Yes. Professionals, we have 2. Both are female. 1 is a woman of color.
And how about for males?
1 professionals.
Well, of the 51, 19 are women, the remainder are men. And
32.
You've told us how many women of color. How many are African American, Hispanic, American Indian?
Asian.
Asian, thank you.
All right. Of that figure, there are 3 males that are diverse background. 1 is African American, 2 Hispanic. Females are 6 African American females, 1 Hispanic, 1 Asian.
We're just talking about the affirmative action.
Okay. And we'll get all that information.
Yes.
Thank you. I appreciate that.
Okay. Any other questions at this time? Yes,
Is this
Ms. Ortiz?
the total of your presentation? Okay.
I
a question. You've presented us with your affirmative action policy, which is good. Are you at liberty to talk about either pending actions for allegations of racial discrimination or any form of gender discrimination, either judicially, or at least could you tell me how many are pending, if at all, and also administratively, possibly in the Department of Fair Employment and Housing?
Yes, I can tell you those statistics. I can't go into the case, naturally.
That's okay.
But be happy to give you those statistics. Mr. Esposa asked to go back for the last 4 years, I believe. Department of Fair Employment and Housing, 1991, we had one, and it was dismissed. 1992, there were two, they were dismissed, and there was one lawsuit during that year.
Oh, one lawsuit, okay.
In 1993, there were no cases before the Department of Fair Employment and Housing.
Oh, good.
There were 2 lawsuits. 1994, there are 8 DFEH claims, which have been dismissed.
All 8 in 1994 have been dismissed.
That's correct.
Is that with prejudice, or I don't?
Are they dismissed after hearing dismissed because they didn't act on them within the statutory time frame? Do you know?
Well, there are various reasons why one may dismiss a case.
Right.
It may be action of the claimant, it may be action by not finding proper evidence to proceed with merit. So,
you have a breakdown on that?
Well, the 8 that I mentioned have been dismissed based on the claimant's request.
On the claimant's request. And then lawsuits in 1994?
There is 1 pending.
And how many were there? How many were there in 1994? Oh, initiated. One initiated in 1994. I see.
Oh, there was one at least settled in
but that was a 1993 case.
Correct, okay.
Okay.
Well, now I'm just trying to remember. This isn't my area of law, that's for sure. But if recollection serves, claimants sometimes ask for their actions to be dismissed so that they can move on to court because the commission can't get to it, essentially, and they have a certain minimum statutory time during which they have to submit it to the commission. Is that right?
I think they either have to exhaust their administrative remedy, right, and then, but it may be possible that they actually have the discretion to use the administrative and or the judicial. My guess is, based on the past history of Department of Fair Employment and Housing, because they have so little staff, because they're so overworked, and most people either go through a pro forma filing and then opt for the judicial remedy. So it could be that they're working their way to the...
Right.
And except those cases being dismissed would no longer be in the respective docket to be considered at that level.
Yeah.
It might be helpful if that information was brought back to us as to what nature of the dismissal of those cases. If it's public record, I assume if it's finalized, it should be, at least the final disposition, the nature of those dismissals would be helpful.
Okay. Maybe we could just have a written report back on that. Any other questions on this matter?
I would just say that in light of the fact that there's a written report that we haven't all seen, we may want to revisit this subject after we get a chance to review that. And I appreciate the oral presentation, but sometimes that raises questions once you get a chance to sit down and digest.
Were you going to comment on the city's recommendations, Mr. Fleming's?
From the last meeting?
It says, the March 21st.
The plan would be, Supervisor Collin, that the city's affirmative action officer take this presentation, the additional material provided by Sacramento Cable, and report back to you next month.
That's the recommendation?
Right.
Okay. And I thought he had said he was going to make comments on that, but he hasn't, so.
Okay. Any other questions for Mr. McVicker? Any other questions from the commission? All right, well, thank you very much for providing us this information. Is there any member of the public who would like to speak on this item? Okay, well, we'll take this under submission. We'll obviously have more written information coming back. Our contractor, the City of Sacramento, will come back with some report at our next meeting.
That's correct.
We'll have the disposition of these cases in writing back from Sacramento Cable, and we'll move forward like that. Okay, well, let's move on to the next item. Are there no other questions? The clerk would please read.
We have cable television legislative policy determination.
Okay, Mr. Spasto.
The pace of change in telecommunications legislative policy is near impossible to keep up with. I've recommended before you 4 broad statements of policy which staff and the commission in the past has been with the chair would use to state our position on both federal and state legislation. At the federal level, there are 2 primary bills moving very quickly through the Congress, House bill and the Senate bill. There's some minor differences between them. The word through the League of Cities and our arm, NATOA, is that there will be a telecommunications policy bill on the President's desk by the 4th of July. Some of the key issues being discussed are those of telco entry, at what speed and what mode, issues of universal access, especially to the information superhighway, issues of costing. Right now, much of the information superhighway has been backboned with public funds. The issues for us coming down quite clearly are what will be the long-term compensation to local government for use of the streets and rights-of-way. First and foremost for you, my cable television franchisees and licensees, but in the future what happens when telephone companies enter into the video marketplace. Will they be franchised? Will they not be franchised? In either case, will they provide any type of compensation? The federal legislation goes both ways. It talks about compensation on the Senate side, but does not talk about franchising on the other side. My concerns are that local government in general, and I've included for you the telecommunications task force from the League of Cities that will be approved here in a week or so and final by the League of Cities, is taking a somewhat salvaging approach. And the concern that local government is evolving to become roadkill on the information superhighway. With that, I'm recommending that you direct staff or you establish 4 policy statements which then we can use to respond to legislation. They are that you would support legislation which compensates local government for use of streets and rights-of-way through franchising or other means. That you support legislation which provides local governments the means to assist consumers. It's one of my beliefs that if we are preempted at the federal level, and that scenario is that if there is competition between a cable operator and telco or a cable operator and another video service provider, our authority would be preempted. And I've put in here that there's a parallel to the issue of placement of cellular towers, in which for a time we were preempted by the PUC, and that local government had no role to play. Some of that is moving forward quite quickly. I believe that local government, no matter what model is used for authorizing access to the streets and rights-of-way, will still likely be the service point for consumers on consumer issues, be it a single provider or any non-regulated telecommunications provider. So I'm recommending a policy which says that we support local government's ability to provide that service and a means to support it. Third, and this is an adaptation of our existing policy now, that we support legislation which maintains local authority over cable television unless competition is real and universally available. The concern I have here is that a paper declaration of competition will not serve our consumers well. We need to see competition exist where a consumer has a second or a third choice for his telecommunications services. And lastly, any legislation which provides additional disclosure so that consumers are better informed and more knowledgeable about their consumer interactions with their provider and can then address those concerns themselves without having to come to us for assistance. With that, I'd be happy to answer any specific questions you have.
Okay, Mr. Costanis.
Rich, I think this is an excellent report. It gives us the background, something I've been looking for. But would you repeat number 3, your proposed policy direction on number 3 again, as it pertains to competition and real or universally available?
Right, I'd be looking for, by this policy, we'd be looking for legislation which defines competition. Right now in the Cable Act, competition has a 2-level definition. One, that the second video provider has access to 50% of the marketplace, as I recall, and serves 20% of the subscribers. I may have those numbers off, but there are triggering elements which in our case If a second provider reached a threshold of, say, 40 or 50,000 subscribers in comparison to Sacramento Cable Television, our regulatory authority pulls away or pulls back. I believe we need legislation with those thresholds that a competing cable system which exists only on paper or exists only to serve a 1% or smaller.
So it defines what a cable company really is in terms of the number of subscribers and their penetration and all of that.
It defines what the competitive force is, and that the competitive force is real. They tried earlier in the 1992 Cable Act to put a term in that the competitive force had an impact on the business behavior of the existing service provider. That got, by our work, that kind of vague term, an impact on the business action, got moved now to something meaning 30%.
Well, do either the two pieces of legislation address that, 1822 or 3636? Do they address item 3 at all or not?
No, as what I have right now is that the term competition is not defined. And that's one of the aspects that I'd like to work with NATOA and the League on drawing forth that definition. Does
NATOA have a position on competition on number 3, or is it something you're suggesting that we ask them to get involved in?
This combines 2 of the NATOA existing policies on competition and universal service.
Okay, Mr. Dickinson.
Following up in the same line as Mr. Costanis, is there something that would define what competition would mean in terms of the provider other than cable television? In other words, if a telephone company or somebody else who wants to get into this market?
Essentially here I'd be looking for policy that parallel would exist in the current Cable Act. And it uses or begins to expand to the term video or alternative video service provider and talks about competition coming from, let me clarify, the Cable Act doesn't do that. The state legislation does. And it would be a merging of a broader definition of video service provider from state policy and the concept of a numerical standard from federal policy that I would use to implement this particular number 3, if I'm helping you.
Yeah, you are, but is that generally defined in terms of some kind of penetration or capital expenditure?
On the cable side, it's defined as penetration. Mm-hmm. That is that the newcomer, the second entrant into the marketplace, has a subscriber base equal to a percentage of the larger of the existing first one in the marketplace.
And if there was whatever satisfied the criteria for real and universal availability such that there was determined to be competition, then would all providers in effect be free from any local regulation and would be subject to whatever FCC regulation is left?
That's the direction, yes, that emerging policy is emerging to. It fits, for the most part, our existing policies now for this commission, which is that when there was competition, we would not regulate. And that has been stated now in the Cable Act. So, yes, when those thresholds were met, it's believed that the marketplace would then govern the activities of the competing entities, and our role would withdraw.
Are you proposing that then language under number 2 would still be developed so that a local authority would retain the ability in a regulatory sense to resolve, or would have regulatory authority to resolve complaints?
Yes. There's state legislation, Rosenthal Bill, that's 1942, which is moving forward now. It has an uphill battle because of, I believe, where federal policy is right now. But what's emerging there is a statement that, first off, a means test, in that subscribers, cable television subscribers, would have a 2-cent per month surcharge that would go to a statewide council for the purpose of allocation then back to local governments for customer service activities. That bill is a little early, but in my mind it's one that says if franchise fees are preempted on the basis that there is competition and the franchising authority's 5% of gross revenues goes away. This would be an alternative means rather than general fund purposes that consumers would pay for having the ability to pick up the phone and call with a consumer complaint on cable television. I personally feel that should be expanded to include all non-regulated telecommunication services.
It seems to me that's the logical question. Should this policy not reflect the point of view that if there's going to be some ability left to regulate and resolve consumer complaints, that it should be across the board to the whole array of providers?
Right. Yes, the issue there, I think, is timing. That larger issue will follow what happens at the federal level between now and summer, and then I would say that we'd have to move from there. I'd be happy to bring the policy back for refinement then. If you'd like to take the broader brush now, that's fine. I've tried to keep the policy statement before you to cable television because that's what our authority is. And much in the League of Cities policy addresses impact on the streets and rights of way. And what I've said here is that I've shared that policy with the public works directors, but the mitigation measures which may be needed to protect the streets, theoretically after they've been dug up the second or third time, is not within the authority of this body.
Well, I understand that, but I mean, if you're going to create the proverbial level playing field with respect to complaint resolution, it seems to me you have to reach all the providers in order to do that, and that ought to be the direction that we recommend for legislation, if that's our interest.
Yeah, I like that. That would be.
Okay. Well, just a question on that, just so I understand. Are you talking beyond the cable realm? Or are you talking?
Yeah.
Sure. For example.
I mean, whatever
any unregulated telecommunication
information superhighway.
Excuse me. So to any telecommunications?
Could be.
Well, I guess
it depends on how you're going to define competition. You know, you're talking about changing the regulatory framework here because of competition from other providers who are currently outside the regulatory setting. I don't know exactly how those are going to be defined as this legislation moves forward, but I would think that if you're going to have meaningful consumer assistance, you'd want to be able to reach those from that standpoint. And certainly if I were a cable provider and I was going to have some obligation financially to finance that, albeit free of franchise obligations, I'd want the other players in that array of providers to be subject to the same thing.
Yes. The question or the answer, and what I can't answer right now, is how that definition will evolve, what that will be.
I think that's the hard part, isn't it?
Yes.
Okay, Mr. Costanis?
You indicated in the report, Rich, that it looks like the information superhighway is headed toward a private sector development. Is there any indication to you in terms of access? Who could access the superhighway and at what charges or anything like that? At one time, we looked at looking at public agencies, particularly education, to have free access.
There's several amendments and several strong aspects to coming in on the education side for schools and libraries to have access, publicly funded or possibly mitigated by the private providers. So that part is strong. The emerging policy is one that appears to be, in order to meet the universal service requirements or the universality aspects, the policy outcome will be making libraries the access point for people who would not otherwise have access in their residences or businesses. So that seems strong. That was in some draft amendments that I saw about 7 days ago. I can't give you their status right now on that one. The cost issue is bigger than I can grasp right now. It's hotly debated. Some discussion about one I hadn't realized until just recently, that besides the issues of base fees and per charge fees and issues of bandwidth and how much data you take, et cetera, one that I didn't realize, but there's a debate over control of the master database of phone numbers, because the sharing of that is what opens up the information superhighway of who's going to have the master registry. And right now, I guess there's portions of the industry that controls that with FCC oversight. That's a new one that I hadn't even thought of, that just cropped up. So the cost issues, I can give you more information as it evolves. I don't know the answer just yet.
Okay, any other questions from the commission? Okay, seeing no other questions. So how are we leaving that
Well,
Mr. Dickens, I guess I'm somewhat concerned. I'm somewhat concerned that that we're venturing into other areas, and I don't have the slightest idea. And it may very well be that somehow those other areas go through this cable of the cable system that we have regulatory authority over. Is that what you're saying?
Not precisely. I guess in my own simplistic way, for example, if you have a complaint about your telephone service right now, you go complain at the PUC. If you have a complaint about cable television, you come here. If you have complaints about other providers out there, I don't know where you go. There's no systematic way right
Under
now.
recent state provisions which you've enacted at the ordinance level, if you have complaints about other video providers, satellite direct broadcast, they come to us as well.
Okay. I mean,
by opening that up, that provides us that opportunity by broadening the interpretation.
Yeah, it just seems to me that instead of isolating one provider, which is essentially what you do if you focus solely on cable television, I mean, that's both unfair to cable and makes it much more difficult to get consumer relief because you're sending people all different places. And you may get varying enforcement vitality from different levels of government as well. And so I'm simply suggesting that 3 is, I'm sorry, I guess really 2 is what I'm on, is too narrow under the circumstances.
And who pays for all that?
Yes.
If I might ask.
Yes, Mr. Purcell.
If I don't have a cable hookup in my house, but I do have some other provider, for example, CompuServe or one of these others, items that hook in my, is the cable subscriber going to pay for my complaint opportunity that you're talking about now?
No, well, I wouldn't envision that. I would envision that all the providers would in some fashion be assessed, which means it comes back reflected in everybody's rates for the particular services they have.
Well,
and that's going to be set competitively.
Then do we go beyond our ability to, I mean, beyond our scope
currently?
Are you talking about CompuServe? Is that a possibility?
Could be.
I guess my concern...
I was thinking more looking at these materials at, say, the telephone company, for example.
I appreciate your concern about some type of mechanism. If I don't like CompuServe, I'll cut it off. And I'm not sure that they're offering cables. No.
I think the example might be here would be the hypothetical 18 months from now that the telco is providing video service.
Telco?
The phone company is providing entertainment video service. It's a distinct possibility in the next 2 to 5 years. If that is provided in a competitive mode under the emerging policy now, it would be preempted. And the access and the rights to do that and the access to the rights of way would come from FCC or federal authority. In Mr. Dickinson's model, if the recipient of that service, a telco-provided entertainment cable service, had a complaint, right now our policy wouldn't address the concept that they pay for consumer services at our level. And I think Mr. Dickinson is saying broaden our policy to include that should that become the case.
Well, it just seems to me that if that becomes the case, then we should analyze that situation then. But taking a position as a commission before that becomes a case, it doesn't make much sense, I guess. And also, I would advise the commission to be careful not to, Rich calls at one end that consumers, we could be roadkill on the super information highway. I wouldn't want to think that we could be putting up roadblocks for the super information highway. The vice president, for example, in his speech to the National Press Club in December, and his release in Los Angeles of the administration's legislation for the year, specifically spoke of the need to have the industries try to flow, try to expand. And try to, and specifically he said to try to deregulate and get legislative bodies out of the super information highway so that the technology could move forward with all vigor and force.
But he also indicated to make sure there was access at the public sector level. Well, that was paramount.
Absolutely.
And that's got to be a part of it. If you don't mind, we can debate the specifics of what you know, the League of Cities has recommended in their telecommunications policy. I think we're on the right track with these broad policies, and I think we just have to watch them. And as these bills become marked up, then I think Rich ought to bring them back to us, and then if we have a position, then we can take them. But try and craft that now, it's difficult because we'd have to craft what the League of Cities is trying to do.
Okay.
So in light of that, I'd like to thank staff and move his recommendation.
Okay, we do have a motion by Costanis. Mr. Purcell, on the motion?
I'm not going to second if that's the question.
Second it.
Okay, we have a second.
I just have a
Got a
comment.
motion on the floor.
I have a comment. The comment is, shouldn't we somehow limit it to the scope of this commission? If we're going to support this legislation, it should be supportable at the level that we're supposed to operate at.
I would think that would be a friendly, that would be something.
That's
That's what we're doing. That's exactly what we're doing. In this motion, we're speaking only,
these broad policies.
and we're speaking only to the Cable Commission and the regulatory authority that we have presently. Because we do have a situation in our community where we have virtually a monopoly. We have a couple of smaller providers, correct? One other smaller provider. But virtually we have a monopoly here. And I'm not an advocate of monopolies, and I think there has to be some regulation of monopolies. But when you have other competition in the market, I don't believe that's necessary. If there's no other question on the motion and the second, any public testimony on this item? Any further commission comments? Okay, seeing none, will the clerk please call the roll?
Yes. Pratt?
Aye.
Costanis?
Aye.
Collin?
Yes.
Dickinson?
Aye.
Ortiz?
Aye.
Smith?
Aye.
Purcell?
Yes.
Panay?
Aye.
Motion carries.
If I would make one last comment, I think it's extremely important that we be as active and effective as we can, as it says also in the league policy, toward that local involvement and local input into this process, because it was a disaster with the cellular towers. In terms of having a state agency try to locate those in all these local communities throughout the state. And the first time the locals began to recognize that there might be a problem with this, the towers were already up. And so I think that when it comes to local streets and highways, when it comes to a lot of other, these broad policies addressed, it's really important to be aggressive in this area.
Okay.
With this
Mr.
policy now,
Spasto.
with this policy now, I can move forward and bring letters for your signature. I will prepare a packet for those of you and your colleagues who are going on the C2C trip, and try and bring telecommunications cable into that as well.
About the capital trip?
Yes.
Okay,
Yeah.
great. I would appreciate it.
Yeah.
Who all is going on that?
I'm going.
Supervisor Cox is going.
Supervisor Cox?
I am going.
Okay.
Roger, are you?
Good.
Absolutely, wouldn't miss him.
Mr.
Okay.
Chairman.
Yes, Mr. Purcell.
The only point I wanted to make earlier was that
Mr. Purcell.
the only point I wanted to make earlier is that telecommunications is too broad a word to use. I mean, it means so many different things these days and so many different technologies. I think we have to be a little bit more specific when we're talking about these items with relation to this commission. That's
Okay, thank you. All right, we'll move on then. Will the clerk please read item number 5?
Rate regulation determination?
Rate regulation determination. Are your microphones on? I'm just wondering. I'm having a hard time. Is it on?
They're low today.
They're low
I'm not
today.
Sure why.
Ours are high, yours are low.
I hear you fine, so
Okay. It doesn't sound like it's on. I agree. I don't think your microphones are on.
My
Can you-
screens
is that-
show they
That's
are.
better.
Yeah,
all right, I'll try and get a little closer to it. I guess
Okay,
we'll go
item
down
number
to it.
5. Mr.
Item number 5
Spasto.
today is a sympathy item to the commission, if we could. If the staff could put the rate regulation formula up, I'd appreciate it. Last week, the FCC released the new regulations on cable television. I downloaded them from the internet yesterday. These are not 3 copies of the same thing. These are all the new regulations. I remember there was a green book of 500 last year, and I'll show you that while it's timely, we downloaded it yesterday morning, I used small type. So we have several hundred pages of information to digest.
And these are
These are the new FCC, this is the implementation, the new implementation of the FCC's rate regulations. Previous to
reduce this to one page, hopefully.
Yes, reduce it to one page.
Well, I'm trying
For
that.
those who want more regulation,
I was gonna show you the formula.
I suggest you read these regulations,
thank
and then we
you.
give you a test on these regulations.
We want the readers to
And
That's
only,
why we wanted it at the local level. We do not produce things like that.
oh, and only if you pass the test, may we pass any further regulation.
The
That
new,
may be a helpful tool.
I don't know if I can get it on the screen or not. The new policy, this is the new formula. If you, it should be on the screen in front of you. You want to dim the lights. This is what, whoops, put it back, please.
Whoops, back.
Put it back if you would. And this is what surfaced last,
What
actually,
surfaced was the point.
yeah, we'll bring it back. There we go. This came across the internet late last Thursday. I have to be honest with you, I thought it was an April Fool's joke. This is the new benchmark formula with a paragraph at the end that says, reduce the end log of the benchmark by 17% and add back CPI from September 1st of
This was on the
82.
LSAT, you know.
Well, it's a good thing we know one member can pass this.
I'm going to, I've sought guidance from my teenagers on trig. I haven't done trig in a long time.
Trigonometry? I didn't even.
With that, the FCC has a seminar next Tuesday, Wednesday, and Thursday, which we'll be attending to try to get up to speed on these issues. This will be the first such FCC seminar since the new regs have been released. They say it's a 9-hour grueling day.
I was going to try to attend that. After seeing that slide, I think we better send your teenagers.
Exit on the superhighway, huh?
Yeah, that exit is gone.
If there's no questions, that concludes my comments on this. We'll have a report back to you in May. It appears that we won't be making rate determinations before July 1st.
All right. Any questions on that item?
The line about additional outlets over total subs, I'm not sure that's the correct formula.
All right. Maybe, okay. Any question from the commission on this item? Any public testimony on this item? Okay, seeing none, we'll be moving forward to the next item.
Chairman,
Item
members,
number 6.
I'll quickly, this is the item on the Scripps Howard Broadcasting transfer of ownership. It's one that
Can
we
I
just...
make a comment first?
Yes, Ms. Collins.
We didn't receive any of this information until we sat down at our seats.
Unfortunately, we didn't come to some closure on this matter until Tuesday.
But, you know, here's what I object to, and I'd like to know what the parameters are. Do we have the ability to continue this for a couple of weeks and have a meeting on it, have a special meeting on it?
That's a good idea,
So we can
Isla.
read this, and so we can have an opportunity to consult on it, and,
Could we ask Sacramento Cable to stop the clock? Is that an option?
Yeah.
You lost your contact?
I lost my contact lens, yeah.
the reason I'm asking
we'll go
that
back to
is
you.
because this has real implications. I'd like to really understand. I know I look at a letter back here at the end, one of the things, and it says substantially similar to. I don't even know what that means. That's in the letter at the end from an April 5th letter to Rich, signed by a Castellini. To me, I really need some explanation, and I'm not ready to act on this today.
Well, we have 2 commissioners are of that opinion. Is there a problem
10 to
legally
5.
to extend this?
Deadline, as I remember.
We were originally,
February 17th was our notice date.
so April 17th. Yeah, we were originally, I'm sorry, my contact lens is going nuts, so if I'm squinting at you, that's why.
Did it take any help?
I will in a minute. Originally, the request for determination on the transfer of ownership was submitted to the commission on the 17th of February. By my calculations, we were supposed to come to some conclusion by April 17th or April 16th, because that was our time clock. Now, I know that there's representatives from Sacramento Cable here today, and they may very well be willing to give us an extension of time for for the hearings.
All right. Well, why don't we bring them up and see if is the legal counsel for Sacramento Cable here? All right.
Yes, I am legal counsel for Scripps Howard. I don't have any authority this afternoon to extend the deadline. To be candid with you, on the basis of the recommendation, that's not an issue that occurred to me. So I do not have corporate authority.
Well, we can meet next week.
We can meet next week, I guess. Maybe.
I move the table. Move the table for, or continue for a week.
a week. It would have to be next week, Thursday the 14th. We have 2 meetings in this chamber, the Waste Authority, and I believe a meeting following that.
Friday.
Waste Authority is 1:30. I don't know how long it's going to take. What's after that?
Perhaps in the morning. Do you meet in the mornings? Does the Board of Supervisors meet Thursday morning?
No.
No,
Does
usually we
the
do joint powers, but
Our experience has been that it's easier to clear the chamber on a Friday. We can call upstairs and check the.
STA meets at 3 o'clock on the 14th.
Yeah, so I
okay,
was just
STA is in
wondering.
here on the 14th. Okay, I'm willing to go on the Friday.
I don't
But
know.
I'm not willing to proceed today because I don't even, this is way too late. I don't know whether that's you or Harriet and,
I think they've just gotten to a point
yeah.
of understanding legally between the two lawyers. Friday the 15th? Friday the 15th.
Has to be in the morning for me.
I think it would have to be in the morning for me as well. Is the morning going to cause a problem Friday morning?
You just have to clear it.
File taxes in the afternoon.
Or
Okay.
extensions, request
So
for
Friday
extensions.
morning, shall we say, shall we say Friday morning the 15th at 10 o'clock?
Okay.
10 o'clock, Friday morning at 10 o'clock. The 15th.
We'll have to confirm a spot.
Why don't we try to confirm the
we'll
chamber
confirm by the end of the
availability
meeting.
right now?
Right.
And then we'll continue on here.
You want me to call upstairs?
Oh, we can call. Okay.
Okay.
Why don't we continue this item until,
You can have.
till the next,
Chairman,
the next item.
7 then? While she's making that call, I can.
All right, let's continue on the agenda. Item 7 then.
Item 7 is a follow-up to an action you took 2 months ago. You transferred the Pacific West license for the area north of Twin Cities Road to an entity called WJBTV. Since then, they've advised us that they are changing the manner, the nature of their business entity from a partnership to a corporation. They're requesting that the Wireless Broadcasting Systems of Sacramento, Inc. become your licensee in this regard. The principles are the same. We've confirmed that the insurance policies are in force. Everything else is the same. At the time they made their transfer to the partnership, the corporation didn't exist. Under your ordinance, you have no basis to withhold this transfer. I recommend that you approve it.
Okay.
This is a license transfer.
Yes.
Okay, it's been moved by Costanis, second by Mr. Dickinson. Any question from the commission on this item? Is there any public test? Excuse me?
Who are the principals in this? Are they
Who are the
local?
principals?
Why don't we have the general manager from, they're doing business as Pacific West. Give the information. Mr. Heil is here, and you may have to file a green slip, but he can tell you who the principals are better than I.
Mr. Stephen Heil.
Afternoon.
Good afternoon.
As Rich said, WJB-TV has incorporated now the same principles, which were really 3 individuals. Dean Buntrock is the B in WJB-TV, and George Dean Johnson. I can explain a little about him if you like. There's one other, Craig Wall was the W in WJB. The same 3 individuals are the principals of the new corporate entity. So.
All right. Any question on that? All right. If there are no questions on that, thank you, Mr. Heil. Any question from the public on this item? Okay, seeing none, no other questions from the commission. We have a motion by Costanis, a second by Mr. Dickinson. Would the clerk please call the roll?
Pratt?
Aye.
Costanis?
Aye.
Collin?
Yes.
Dickinson?
Aye.
Ortiz?
Aye.
Smith?
Aye.
Purcell?
Yes.
And Panay, aye.
Panay.
All right.
Motion carries.
The motion carries. Next item, item 8.
It's an item in which your franchisee and licensees have an opportunity to present comments to you.
Okay. Mr. Howell, you were just here. Would you like to comment? Either
to say.
No one has anything to say? Mr. Heil or, no? No? Okay. Sacramento Cable has, who would like to come up for Sacramento Cable? Okay.
I just took them out. I got some more. It's right over here.
I'm Darby Patterson, Community Relations Manager for Sacramento Cable. Sometimes when I come up here, I feel like comic relief. I get to say some of the nice things that we're doing and some of the things we're real proud of in the community. What I'm passing out to you today is some information from a recent summit on school violence, which we co-sponsored, and we were some of the prime movers behind it. And it was an all-day event for about 150 members of the community, and it was a really unique approach to a problem that affects every family in Sacramento, and that's the growing, random, and really senseless violence that we're seeing in our schools. The solutions that were presented during that day, which were often really very dramatic, will be given to a group of people who have committed themselves to work on this for an entire year, and it's a very big volunteer commitment. Among many of the ideas that came out of that was that families really need to take a more active role in the schools, and that moral values ought to be taught right along with academics, and there should be some kind of partnership with the media so that we hear about positives along with hearing all the negatives that seem to be battering us every day. And that teachers really ought to have some training in multicultural sensitivity. And there were some other real radical suggestions, such as uniforms, dress standards, and closed campuses. And I hope my son is not listening to this. Nearly every group that issued a report said that racial tensions were really an important part of fueling violence in the schools. All in all, it was a really intense and productive day, and I think it's going to go a long way toward helping our schools here. As you know, we've really supported the arts here, from theater to opera to the symphony, but without a really safe and secure environment, I don't think any of us can really enjoy these cultural treasures. So Sacramento Cable is really committed to working with law enforcement and with the schools this year toward that goal. On a similar topic, we also hosted Court TV in March, and we filmed a town meeting at KVIE, and it was hosted by Arthur Miller. The topic was crime and punishment, and by the end of the 2-hour filming, it stirred up a whole bunch of emotions from Sacramento residents. So I hope that you'll all have a chance to tune into that. It will air on Wednesday, April 13th at 7 p.m. on Channel 41, and you'll certainly recognize a lot of the people there. We're also really excited about tomorrow night's opening of the new exhibit at the Discovery Center, Return to Gold Mountain. This chronicles the long history of the Chinese community in Sacramento. And dozens of people have been working just furiously to get this ready for tomorrow, and hoping to make it one of the best exhibits that the museum has ever had the pleasure of hosting. They've been sifting through generations of artifacts and memories, talking to people. They've been painting and building. They've constructed an herbalist shop with a little room behind it that the Chinese family called home. And ironically, your building right here is at the far eastern end of what was once known as Chinadom. Sacramento Cable and the International Channel have been real privileged to be a sponsor of this exhibit, and I'm personally grateful for the opportunity to talk to a very distinguished woman named Mrs. Anna Lee, who is the guest curator and a historian and an artist and a number of other wonderful things. And she guided me through writing some of the portions of the explanations for the exhibit. And I hope that we'll all get a chance to really enjoy this. It's a wonderful gift from our Chinese American friends and neighbors. And once again, I want to thank you for the opportunity to share all of our community service projects. And if you have any questions, I'd be happy to answer.
Well, very good. Thank you for that. I hope my daughter is watching about dress codes at school. She's entering kindergarten coming up.
It's important to start very early.
Yes, it is indeed.
Yeah, my wife and I have both spoken about dress codes and what a need there is in the public schools. I don't know if she'll appreciate it at this point, but at 4.5.
Mm-hmm. Well, there was really a lot of agreement about that because clothing causes so many of the problems and distinguishes one group from another, and there was really a sense of we really need to crack down and take some control, and that really was an issue.
I agree. Okay.
Thank you.
Mr. Grover, Sacramento Cable.
Thank you, Mr. Chairman. As always, our remarks will be brief. The most important thing to report is our telephone statistics for last month. There's no more important community relations project than answering our phones and serving our customers. And through the heroic efforts of our 93 customer service representatives, last month we were able, while we still had 189,000 completed telephone transactions, we were able to reduce the average speed of answer, or the hold time for a customer calling in, to 15 seconds. As a matter of fact, even if you eliminate from that all of the automatic answering services, the audio response unit and ANI, pay-per-view, etc., the number then is still 22 seconds. So that's the result of a lot of hard work. We're going to continue with some efforts in the next month or so. When we do our next disclosure, consistent with our rate changes, we plan to shorten our hours so that we can provide more firepower during the hours that we're open. Ultimately, we believe we have to be a 24-hour customer service organization, but our short-term priority is to make sure that anyone who calls in gets a response in a few seconds. So we plan to do two things with our next disclosure. One, to shorten our hours from the current 7 a.m. to midnight to 8 a.m. to 8 p.m. for new service and billing, and for those who need repair assistance, that would be from 7 a.m. to 10 p.m., while, of course, we would continue to have 24-hour emergency repair service. And we also plan to specialize our lines, and we've had some discussion on this in the last few months at the commission meetings, into separate sales, repair, and billing areas so that we can train customer service representatives to handle all inquiries, but to have some of our CSRs specialize in some of these functional areas. With that, just have one or two more brief things, and then we'd be happy to answer any questions you might have on programming or service or any other issues. For the last several months, there have been complaints that have been attached to the agenda. Maybe that's gone on for longer than I've remembered, but I do want to emphasize, I'm not sure exactly what the point of that is, but I do want to emphasize that we have an aggressive response to complaints, both received through the commission and directly to us. According to our able commission liaison, Regina Van Zant, we received 51 complaints in the month of March. 49 of those are resolved, and there are 2 outstanding complaints because of specific reasons that require additional follow-through. We have asked for weekly reports from the commission staff on complaints for some time, and perhaps that would help us to provide even more responsiveness. But that's basically all that I have, and if you have any questions or concerns, I'd be happy to answer them for you.
Questions from the commission? Okay.
I have a
Just
question.
Mr. Costanis?
I have a question. Maybe this is directed to Rich, and maybe you referred to it, Brian, but there is some personal information in our agenda packet regarding phone numbers and addresses and names and so on. I imagine there is, at least it occurs to me, as some privacy information that should be respected. I just wonder how we're dealing with that.
Our policy has been, Mr. Chairman, that if and this goes back to access in one of the current lawsuits, that if information is within the commission's records, it's available under the Public Records Disclosure Act. So phone number, address, by the nature of a citizen calling us, it becomes public information. We haven't adopted a policy of disclosing that at the time. We've assumed that to be the case, that there's listings in the phone book, et cetera. That applies to the computer records and the written records as well.
Mr. Gruber, then, is that disclosed? I mean, do your customers understand that?
Probably not, but I assume if they were to ask the question to someone at the commission, they would be able to get that answer. But I doubt that among our 250,000 customers, there's a thorough legal understanding of some of those issues.
That'd be good information to provide to the consumers if you're to consider that and think about it.
Okay. Thank you.
Yeah. I'm understanding the distinction, and the distinction then is if they call in their complaints to you, that's proprietary information. And if they call in the complaints to our offices or the Cable Commission, it's public information. Is that what I'm hearing?
That's correct.
Okay. And so, you know, I do not know when people do that, whether they realize or not. I don't know if that's your responsibility to tell them or ours. Certainly when people have written letters, I have tried to explain that if they're in my files, they're subject to public records.
Okay. Just we increased our service And someone called and gave us a pitch from Sacramento Cable to increase another channel, plus get a free channel for 30 days. And if your folks are going to say, you know, it's going to be on by 6 o'clock, it should be on by 6 o'clock. And if it's going to be on the next day at 6 o'clock, then say the next day at 6 o'clock. But, you know, when you have anticipation that it's supposed to be on by 6 o'clock and it doesn't come on, the people who were hoping it would be on by 6 o'clock get a little upset. So, and it wasn't on by 6 o'clock. So I don't know how that works technically. I'm amazed that it can work, you know, you just do something, you know, punch something into the computer. But if you could, I don't know, do you know how that works?
The sooner we can get the service on, why, the sooner we can start charging for it. So it's certainly our policy to get it on quickly, and we do have the electronic capability to deliver that service immediately. On occasion, if there are billing problems or delinquency problems or various other technical issues or whatever, I'm not speaking of you, of course, Mr. Chairman, but sometimes there may be technical reasons why there would be a delay, but certainly if you were promised that and we fell short, then I apologize for that, and there should be no reason. But did you upgrade your service, Mr. Chairman?
Well, yes, and then I had to finally figure out how much we're paying for our service, and then I said, you know, I can't believe this. Cable was supposed to be very low cost, no advertisement. Wasn't that the concept behind cable originally, that there'd be no advertisement on these channels? I may be missing something. No?
No, I don't. I think that early on there were some expectations of commercial-free channels, and there are certainly on the premium level commercial-free channels, and a few on the basic level, such as C-SPAN and Metro Cable and others. But in order to provide dual revenue streams for programmers to invest in new programming, they receive approximately half of their revenue from license fees and half from advertising.
I see. Okay. Yes, we did upgrade our service and have a third premium channel now.
Well, God bless you, Mr. Chairman.
Well, I don't know if the Almighty has to be blessing me for that for you, but if that's what you'd like to say. Anybody else? Any other questions, comments on this?
I was touched by the emotion that's flowing back and forth.
Well, I have to say, though, I am looking at the competition because I always thought it was a novel idea that we always got our TV wavelengths through the airwaves prior to this wire coming into our home, and then it just kind of went by the wayside, that whole concept of doing it through the airwaves. So I'm reinvestigating, not to say that, you know, we're just going to...
It is not obsolete in my home. I have rabbit ears.
You have rabbit ears?
Rabbit ears
there you go.
On most
but
of
we
my
are
TV
investigating
sets.
the competition.
That can be treated now, you know.
Well, this conversation has degenerated to a point.
It's after 5, that's why.
Okay, well, thank you very much. Appreciate your comment and testimony.
Mr. Chairman,
yes.
On general status of the franchisee, I spent yesterday with our engineer, Dane Erickson, from Hammett Edison, based on your authorization from January, and we visited 6 subscribers who had filed with the Commission reception quality complaints. The result of that was one subscriber had a defective TV set. The other 5 had pictures of exemplary nature, of A- status. Dane continues to be impressed. I'd comment that, as near as we could tell, your action to initiate the reception quality tests in January followed with Sacramento Cable Television following up in late January through to last week in each of those locations. In one in particular, there had been, I believe, 3 service calls that had not been resolved. On March 21st, the technician stayed there till the problem was resolved. It was not the subscriber set. It was not internal. It was a reception problem that was about a half a block away on the pole. So the reception quality based on that sampling is excellent, but too, I would offer that your intervention, your looking at reception quality, got those 45 or 50 cleaned up very, very nicely.
Well, that's good. My reception problem, since I'm airing all my laundry, was that we had looped our wires so that it wasn't one, or no, you have to loop. We didn't loop. We went one straight wire and kept going to many different outlets, and that seems to present a problem to reception quality.
You're in or out of the loop.
We are out of the
You
loop.
think he's bad here, you should see him at Regional Transit when he explains all the buses he rides and his bicycle problems.
Well, you know, you've got to use the service, and I'm seriously contemplating the wireless service just to see what it's like, comparatively speaking.
Well, we'll look forward to that report.
You will. All right. We have, thank you. We still have a couple of other things here. Yes, thank you, Mr. Gruber.
Mr. Clear with this item. Backing up to your continuation item, as we checked, this room is booked at that time, but the city council chambers is available. We've reserved it. So if you would continue item 7 to next Friday, item 6 to next Friday at 10 a.m. by formal motion, we would not have to renotice.
Okay, it's been moved by Mr. Costanis, second by Ms. Collin.
Yeah, to continue it to Friday, April 15th, 10 a.m. at City Hall.
At City Hall, 10 a.m. Friday, April 15th. Item number 6.
Pratt?
Aye.
Costanis?
Aye.
Collin?
Yes.
Collin. Dickinson?
Aye.
Ortiz?
Aye.
Smith?
Aye.
Purcell?
Aye.
Panay?
Aye. All right.
Motion carries.
So,
Item 9, and then you do have a closed
item
section.
9.
We have no speakers signed up.
No speakers signed up on item 9. Anyone in the audience who would like to address the commission on items not on the agenda? Okay, seeing no.
I'd like to add one thing
members
just
of
for the record,
public.
Mr. Chairman. Your Metro Cable staff, in conjunction with the League of Women Voters, have scheduled numerous election forums this year on Saturday, April 30th, Saturday, May 7th, and Saturday, May 14th. They'll be in this chamber. They'll be cablecast live and repeated. We've expanded our coverage to include state races and forums as well. To those of you who are participating, that's great.
I have a question from Ms. Ortiz.
Yeah, I appreciate this. You might want to let the League of Women Voters, let those of us that are,
candidates know.
the candidates know.
Oh,
about it.
certified letters went out today.
Well, it's candidates?
Yeah.
I think one of our commissioners may have a problem with one of those dates, and she just may be one of those candidates.
Right.
That would be me.
Okay, within the overall, we do the telecasting service. The overall management of the forums is provided by the league. I felt I wanted to get you the information now because we wouldn't be meeting again. But I understand that certified letters to all the participants went out today.
Actually, I think there might be a couple of commissioners that might be concerned about the dates here.
A couple of commissioners.
I do see a date.
You do see a date.
You don't even know if I'm going to be in Sacramento. I don't even know you.
In my council seat, I'm working with Access Cable, and I was going to speak to the Metro Cable about hosting a forum. Since I'm not running, I want to make sure that the candidates in my district have an opportunity. So I'm going to be hosting a forum for the candidates in the 3rd council district. So.
You're not going to ask the questions, are you?
And I'm asking the questions too.
We'll look forward to that as well, Mr.
Well,
thank you all.
Okay, thank you. And now we have
A closed
Mr.
executive
Spotswood.
session on litigation.
Yes, we have a closed session, and we'll be recessing. We'll have to come back in open session after our closed session to report any items to the public. So those members of the public who would like to stay around. Excuse me? Do you need to? Yes, that's the new rule.
We have no action recommended, but we
It only
still have to come back
applies to
and we have to report no action as I understand it, and then adjourn the meeting formally.
Okay, so we'll be coming back after our closed session. We appreciate all the public's attendance. We'll be recessing to closed session to take up this closed session item.
Right,
If the
and-
clerk would please read. Yes.
Okay, never mind. Just, I was going to remind you to have the clerk read the.
Yes. If the clerk would please read the last item in closed session.
We have closed executive session, conference with legal counsel, existing litigation, government code section 54956.9 sub A, County of Sacramento et al. Versus Protective National Insurance Company et al. And Sacramento Cable Television versus Sacramento Metropolitan Cable Television Commission.
Okay. Then we'll recess into closed session. We'll go right into this room off the chambers, and then we'll come right back after. Excuse me, Ms. Collins, you have a problem with
I was
that?
going to say, we're going to squeeze in there.
Well, we're going to squeeze in there just because we're going to come back. We have to come back into open session after that.
If we have any.
We also have the room upstairs available if you
Yeah.
care to.
Yeah, that's only if we come to a.
Let's squeeze in here for now, and then see what, how we can get through this item. Litigation, and have discussed that litigation, and the commission has taken no action. So therefore, we will, we have a motion to adjourn this meeting by Collins, second by Purcell, and
Unanimously agreed to.
we're adjourned.
I saw that. That was Higgins.